as regards the stage when prosecution for a criminal charge can be stated to be pending, the said OM rated 4992 does not specify the same, and hence the definition of pendency of judicial proceeding in criminal case given in Rule 9(6)(b)(1) of CCS Pension Rules 1972 is adopted for the purpose. The Rule 9(6)(b)(1) of CCS Pension Rules provides as under: judicial proceedings shall be deemed to be instituted in the case of criminal proceedings on the date on which the complaint or report of the police officer of which the magistrate takes cognizance against the statement of which, assuming that it was only simpliciter mallet, the date on which the challan is filed, there was no requirement of saying. Naturally, when the challan is filed, the court it is going to take cognizance thereof. What was the requirement? It has to be the court should have taken cognizance. And why not we come to page 73.
Case of a criminal proceeding on the date on which or a report of police officer of which the state takes cognizance is made.
And when this charge sheet was filed on 29/7/16, this is what the court has to write, that we are not taking cognizance hereof, but we registered. Without simpliciter, we are registering the offence for our purposes, but we are not going to deal with this issue. We'll hear both the sides and then whether we are going to take cognizance or not. उच्च न्यायालय जबलपुर में सुनवाई हेतु दिनांक 1/8/16 नियत किया आवेदन में प्रकट किया गया है कि मांग और ट्रैक की कार्रवाई अभियोग पत्र के अनुसार भोपाल में घटित हुई है.
No, this Mr. Sharma, this is made at the end.
Yes.
Creates a little doubt that whether it is the filing of the charge sheet or the cognizance. They could have more happily worded that provision.
My submission is, if what the my learned opponent wants us to take on, it is the moment it is filed is the end of the matter. Why the other subsequent words would have been used? It could have simply said from on the date when the charge sheet is filed, end of the matter.
That's
Yes. And here I am pointing out when it comes to 73, the court says that although the charge sheet has come, but we are not taking cognizance thereof. We'll hear the party law. It's very clear. विचारोपरांत समय प्रदान किया गया, इसलिए अभियुक्त के विरुद्ध बिना संज्ञान लिए अपराध अंतर्गत धारा इतना भ्रष्टाचार ने विशेष पंजीकृत किया. Not taking, then he heard of some cognizance.
There must be some decisions on this point. Some other decisions of other courts on this point.
But everywhere, what I'm saying is that this pension rule and that circular is followed. And in my peculiar facts and circumstances, although the charge sheet came to the court, but court itself subsequently heard us and subsequently took cognizance. The cognizance was taken on 11/6/2018. It says that yes, I'm taking cognizance. There's a gap, my lord, of 29/7/2016 to 11/6/2018, and that and subsequently on 25/6/18 charges were framed. While my DPC itself took place on 4/1/2018. So as on date, my lord, I was clear. That's what I'm saying. That's what the tribunal agreed to. And here is that it's not. The issue is not with regard to any. This is only a simple financial accreditation. If you complete 4 years, it is NFU, non-financial accreditation. Non-functional accreditation. After completion of 4 years in JAG, my lord, I get the second stage of the pay scale.
All right, we heard it sometime.
Could it come, my lord, because of which one of the pensionary benefits to the widow and the children? So I'm in May.
Yes, he has retired and expired.
very unfortunate, very small game, cheaper and
इसमें लिखिए that the matter has to be finally heard. And looking to the fact that it pertains, it will have repercussions on the terminal benefits due to the LRs of the deceased respondent. This is the case for hearing on 15th May. In motion. 15th.
November 24th, with connected matter Sri Rameshwar Singh Thakur, Uttam Kumar Jain.
ये वाला आज पास हुआ तो उसमें वो आ गया आपका you had to prepare some chart or something based on that clarification of Devesh Sharma. आपने बनाया कि नहीं? Last time I think state was directed to file a common tabular illustration. Common करा है आप लोगों ने? पास हुआ? All right. अच्छा 2:15 का तो ऑलरेडी है इसमें 2:15 लेंगे इसको
November 25, with connected matter Sri Vinayak Chitra Sahab, Dhanendra Mitra.
Yes. Reply 5. आपका एडिशनल रिप्लाई आ गया एडिशनल रिप्लाई पैरावाइज दिया आपने वो आ गया टेबल कहाँ बनाई है उसी में जवाब में टेबल किस पेज पे है तो इसमें आपको ये मिल गई टेबल कॉपी मिल गई आपको रिजॉइंडर कब पेश किया आपने रिजॉइंडर कब पेश किया 22 अप्रैल 22 तो मतलब मंडे हो गया है क्या रिकॉर्ड पे लिखिए टू द additional reply filed by the state the petitioner has filed the rejoinder on 22nd of it has not come up register to verify and place it on record just next week same issue
We have raised more ground in this case also, but since the state is to be very provisional, which has been undertaken and just before the division. Ideally, one of my matters would go before the Honorable Prime Minister because no virus or vaccines under that. Not of that sort. I have earlier submitted this all.
No, last time you had been asked to file an application to complete that you filed.
5531 and 5534 of that.
All right, इसमें point 1 में application for amendment है उसको allow कर दीजिए. What about the appointees?
There are two applications for now. One, completed the appointees are party, one.
अच्छा, दोनों को allow कर. How many? 2. वो ओबीसी से आ जाता है ना डीबी में. ऐसा कोई ऑनरेबल चीफ जस्टिस का एडमिनिस्ट्रेटिव साइड का ऑर्डर है कोई? हाँ ऐसे है.
So if my case papers are not complete, they may file a reply to my application or petition or so that can be heard and all of this otherwise it will be difficult for me to not.
Point 1 will let reply be filed by the state and let notices be issued to the newly added respondent on payment of PF within 7 working days. This returnable 6 weeks. और नेक्स्ट वीक मत करिए इसको, उसी के साथ क्लब हो जाएगा. 25 जो है वो 25.1
Number 26, the Parliament Trivedi, Kumar Khan.
26 में थे. कोई एप्लीकेशन लगाई आपने? जॉइंट एप्लीकेशन 13B की. लास्ट टाइम तो इसीलिए मौका दिया गया था. $7 लाख में तैयार नहीं है. कितना मांगे? हाँ, आप हस्बैंड के लिए हैं. हाँ 7 लाख. 7 लाख किसकी डिमांड है? वाइफ की? स्त्रीधन वाला. इसमें कौन सा ऑर्डर चैलेंज है? 'Section 13 पिटीशन डिसमिस्ड. अच्छा, रिकॉर्ड आ गया इसमें.
प्रपोजल क्या है इसमें? आप डाइवोर्स चाहते हैं ना? क्या प्रपोजल है आपका? हैं? नहीं, क्या आप वापस रिटर्न नहीं करना चाहते? स्त्रीधन रिटर्न नहीं करना चाहते? नहीं करना चाहते, क्यों?
इसका डिसमिस
स्त्रीधन के बारे में
27 का जो आवेदन था वो बिना गुणदोष पे डिसाइड किए निरस्त कर दिया. साक्ष्य के अभाव में निराकृत नहीं किया जा सकता. साक्ष्य आपने दी नहीं तो कैसे करेंगे? ये इस तरह उक्त आवेदन 27 साक्ष्य के अभाव में निराकृत 31 में है लास्ट. साक्ष्य के अभाव में कैसे डिसाइड करेंगे जब आपने साक्षी नहीं दी? 22 पेज 22 में देखिए धारा 31 पढ़िए साक्ष तो देना था उसको वाइफ को देना था साक्ष तो भाई गवर्नमेंट के सब कार्य नहीं किया नहीं पर कुछ सीधों में तो है नहीं लेकर ही नहीं है नहीं 27 का आवेदन तो वाइफ का था ना हाँ आपने तो चैलेंज किया नहीं हस्बैंड ने चैलेंज किया है हाँ 27 का इशू ये हस्बैंड कैसे उठा सकते हस्बैंड नहीं उठा तो आपका सेटलमेंट का क्या हुआ है भाई आप लोग साथ नहीं रहना चाहते ये तो तय हो गया है सेटलमेंट कुछ अमाउंट का करिए फिर 12 से 7 आए बताइए 5 या 6 में आप मानेंगे हाँ कैन यू कम डाउन 5 and 6 on a learned counsel for the rival parties seek and are granted further time to seek instructions as regards the pursuant to the order passed by this court on 2/4/24 list after the summer vacation.
नंबर 27 से अशोक कुमार चौरसिया उनकी चतुर्वेदी
Yes. इसमें सेक्शन 24 का जवाब आ गया तो आपने काउंटर नहीं दिया आपने काउंटर एफिडेविट दोनों ने बताइए यस यस बताइए कोर्ट में नहीं आया कब किया आपने yesterday reply affidavit to the application under section 24 of the wife has been filed by the husband yesterday which is not on record registry to verify and place it on record next week huh 2 weeks आपको जल्दी नहीं है?
स्टे लिया है सर, इसलिए वो
नहीं, नेक्स्ट वीक लेंगे, नेक्स्ट वीक।
नंबर 28 गोपी चौरसिया आकाश चौधरी।
Who was unrepresented? Who is two?
Promotion order was certified by the class. Not even set aside because said that it will come.
तो ये कोई respondent two की तरफ से? Who is for two? Nobody. You are for one.
About one.
बीस दो चौबीस को रिसीव हो गया नंबर 2।
We get that it is sent by registered post. So the respondent number one has been served on
नंबर 2
on number two. Served on these though. Yet there is no representation. Next. Then what has to be done? All right. We let the case be heard on admission. Sometime. The urgency. July. Just in July.
नंबर 29 CNS दूसरा DPC।
I know the law, that when the matter goes to the Supreme Court, so generally we don't press the contempt. My lord here, my lord has been pleased to decide the matter on 13/6/2023. The time frame की भाई इतने दिन में आपको इनको अपॉइंटमेंट देनी है. It is obvious that live registration with employment exchange has no bearing with the eligibility and suitability of the candidate. और सुप्रीम कोर्ट का प्रीति लतानंदा केस है. अब सुप्रीम कोर्ट इन लोग जा रहे हैं, that is the time barred SLP, उसका डिफॉल्ट नहीं पूरा कर रहे हैं. They are making no effort to get it registered. Let my learned friend say कि हम 1 महीने 2 महीने 3 महीने, मतलब they are only gaining time कि मेरी पूरी जवानी बीत जाए.
ये जो petition, ये order है सुप्रीम कोर्ट का, this is state versus अश्विनी. ये अश्विनी कौन है? अश्विनी was not party. महेंद्र सिंह ठाकुर, ओम प्रकाश, तृप्ति, महेंद्र सिंह सिसोदिया, कहाँ है इसको?
पंच में सब पंच में. I think I'm here. I'm there. My humble request is time pass no effort to rectify the defaults and keeping the pending before the Supreme Court, my lord. But अच्छी बात नहीं. Delay has been confirmed. Get it listed, get it argued. You can't argue it because Supreme Court, 15 cases are against you.
You know, where is
live registration?
no, Mr. GP Singh, where is Ashwini? First name is Ashwini. अश्विनी इसमें कहाँ है जो पिटिशन डिसाइड हुई? अश्विनी का पार्टी नहीं है इसमें. On hearing transfer, delay condoned. Tag with SLP 38819. ये क्या है? Tag with 38819. 1878. One 3 9
My lord, let my learned
Yeah.
that within 10 days, 15 days, 20 days, I will make no effort to get my SLP
But this is-
decided.
This is not the relevant order.
But इसके बाद
इसमें जो ऑर्डर चैलेंज है हाई कोर्ट का वो नहीं है ये
इसके साथ कनेक्ट हो गई, इसके साथ और कनेक्ट
वन टैग किसके साथ हुई है नेक्स्ट पेज पे देखिए
डायरी नंबर 38819
38819 स्टेट वर्सेस मोनिका शाक्य मोनिका शाक्य इसमें है क्या
वन का भी नहीं।
पहले वाले का डायरी नंबर 40766
अगेंस्ट
which party. This particular which Mayan Bhagat.
ये कब लगा है पेज
ये अभी डेट बता रहा है, इसके आगे का डेट अभी नहीं आया।
कब का है डेट लास्ट लिस्ट 13/1
Technically speaking, my lord, there is no interim order by the Supreme Court. Matter has not been admitted. They are bound to comply with the High Court. On page the content. I am making a statement to the bar not that they find a time barred SIP.
ये मोनिका शाक्य भी नहीं है इसमें पार्टी कौन से ऑर्डर्स दे रहे हैं आप मोनिका शाक्य वाज आल्सो नॉट अ पार्टी देयर
I thought with
इसमें पार्टीज होंगी ना ये कई सारे एसएलपीज मेंशन्ड है इसमें तो पार्टीज होंगे वो कहाँ 18/7 list again on 18/7/24 All right. All right.
So that's the news.
Yes, yes. हाँ ये 4-5 है ना इसमें मेंशन हाँ है
It could be taken next week or not. But
नहीं इसको निकाल के लाइए पास ओवर करते हैं चलिए so that we have the correct picture yeah 50 ऑर्डर में मेंशन
Children में 30
चार या
Sunday
पांच
कुमार अग्रवाल
OA reply rejoinder have you filed it all right Shri Yashovardhan Jain prays for and is granted for the time of 2 weeks 3 weeks 3 weeks to comply with order 21/3/20 list after 3 weeks
Roll number 31 P Ratnesh Kumar Yadav
the car has been filed. The local transit time to service the final of the case. Only submitted that the people who not wish to file the paper and would like to heard this matter on petition.
yes any objection all right
It could be taken upon.
this security paper mills this Service matters are not notified for tribunal. No. Okay. Honourable counsel for the petitioner fixed time to argue on admission list after 2 weeks.
Number 32, CSS Indian Toxic.
Huh? Learned counsel for the respondents, all respondents. 2 to 3. Pray for an grant. Until how much time do you want? Until time to file the reply during the course of this week. Let the same be done list after 1 week. IR to continue till the next day.
Number 33 with connected matter. Akashni Trivedi, Ritika Chauhan.
Yes. We had issued notice to respondent number 4. You are appearing.
He is the official because he had not even appeared in the tribunal.
Respondent 4 में क्या हुआ है? Service हो गई क्या? देखो. Which is the tribunal's order? P1. Your case has been dismissed. Notice sent to the respondent 4 has been delivered. Be safe. Yet there is no representation. We admit it. If you want, you can argue it. Which document? Tribunal.
Online my friend can easily download it.
What is the point involved?
Point involved is because we seniority. What had happened was we were working at Armangadu. We were working on the post of ID skill worker. We made a request for transfer to level 4 and that was accepted. But with the condition that we will be reverted to skill. However, that was also acceptable. So we came to skill grade, but instead of fixing our seniority properly in skill grades, they put us very bottom of the skill grade. But only down 1 grade, but bottom of that. We made a representation that
So that was a request transfer.
Yes.
So obviously, you will be fixed at the lowest.
But even if they my seniority should have been mentioned as per office memorandum. I made a representation, they corrected it.
Now, what had happened, one of the promotion exercise took place, first and juniors was got promoted. Now, by defense first, since you do not have the skill test, you could not be promoted. Now, submission is that you send people for skill training at the ratio of 1:3 on the basis of seniority. So, had seniority been correct in the skill grade, I would have gone into training, I would have got the promotion. Because subsequently also I got it followed. I have passed it. Previously I had passed it. I passed it in Urban Garden also. So that is the issue. But why are placing me incorrectly in the grade buffer?
So the same issue was decided earlier.
Both connected buffer. The connection one is the connected buffer that was decided earlier.
All right.
Both of them are
मैंने के WP में दोनों में the hearings are complete and the matter can be finally heard. The WP is admitted for hearing list in July 20. Final hearing list of July 24.
Case number 34 with connected matters to be published. Case Srivastava.
Yes, the interest amount has been paid or not?
The interest has not.
Okay.
Interest has not been
Yeah.
paid. But the amount has been paid. But in the start, we have declared and it has been paid, it has been paid for.
Now started the supply to me money, to eliminate money. So make ID verified the chart money. Apart from that, other thing my number that my responded that with the intent. And they have also not paid the amount from the January 24 to 29.
That is being paid today. That is being paid today. It will be transferred to their.
So you please verify the contents of the chart. How long will you take to verify? 2 weeks. So we'll list it after 2 weeks.
Maybe it's the below, but estimate, but I'm the social organization is so body, because this is an industry. In which this is an expert society and working for the welfare of the.
Final hearing will only be possible after the vacations, not before that.
It may be not after vacation, but we want to, there should be finality.
All right, the tabular illustration.
In between, they may verify,
Yes.
consolidate their claim.
All right.
If it is visible, germane, then we comply with it.
The employer petitioner, the employer appellant has filed a tabular illustration revealing the interest paid to the workman in terms of the order of the apex court and the.
No, the interest has not been paid for this period. The interest was paid in the Supreme Court order.
Yes, yes.
Yes.
In terms of the order,
It's all that.
yes, in terms of the order passed by the apex court on 19/2/15 in civil appeal 470 of 2008. Next, Learned counsel for the respondent workman thinks and is granted 2 weeks time to 3 weeks time to verify the contents of the tabular illustration. Next, since the matter is of 2006, let it be taken up for hearing on any Wednesday, Thursday in the month of July. In motion. Yes.
My submission was particularly in this in 16, February 16, no, till the date for they have not put the intent. Now we have verified that.
If you have any objection to that table, then you make a affidavit, file a affidavit. You can orally tell us, you can orally tell us in the final, at the time of final hearing.
That would be done, I'm done.
Because then there will be no end to this completion of pleadings. It will never be heard.
Roughly 1 crore rupee that we have.
Open matter, then we have raised the objection and pointed out about the matter. Some point.
Already,
We raised that point on that.
Honored counsel for the workman is free to respond in writing to any objection to the affidavit, to the tabular illustration before the next stage of it.
November 35, Sri Pritesh Kumar Srivastava.
Pass over. What has to be done today? Finally heard. No, because Mr. Rupra is appearing, so it doesn't go to DB1. Because he is appearing in this case, that is why it cannot go to DB1. So that order has been withdrawn by Honorable the Chief Justice. So there was some order that Mr. N.S. Rupra's cases will not be listed before Division Bench 1. Please show that order. Some judicial order must have been passed. All right, we'll pass it over. We'll be relieved of lot of burden.
November 36, connected matters, the Gujarat, that forest officer.
Yes. First appeal has to be heard finally. Huh? Are you ready? We'll pass it over and hear it. There's another. तो आप लोग अपना आर्ग्यूमेंट शॉर्ट कर दीजिए.
अब इनका है सर हमारा तो जो है कि
Take some time. Because we've already listed one matter for hearing today in the post lunch session. Vacation के बाद करेंगे. Learned counsel for the rival parties do not dispute that or this matter has to be finally heard and some time would be consumed for this thing. Accordingly, list on any Wednesday, Thursday in the month of July.
Number 37, the Sankalp Kocha, Mahendra Niwasi.
कौन सा ये? Yes. 215 will take it up. This is 37. 37 में last time there was direction. Paper book is not there. बैठे हुए.
काउंसिल को इन्फॉर्म किया गया परंतु पेपर बुक लिस्ट फाइल नहीं की गई. इसलिए उनको लिस्ट फाइल करना.
आपने लिस्ट फाइल नहीं करी है पेपर बुक की, अभी बना नहीं है. All right, learned counsel, this matter had been heard listed today a final hearing in motion on at 2:15, but it is informed that the counsel for the appellant has not done his part, has not complied with his part of the process of paper book preparation. Next. इसको करना क्या है?
दोनों रिस्पॉन्डेंट और प्लान दोनों के एडवोकेट को लिस्ट फाइल की कौन से
Let
एग्जिबिट चाहिए
Let list be filed.
पेपर बुक बन
Necessary list be filed before the registry for preparation of the list after 2 weeks, 3 weeks. Yes,
सिद्धार्थ से बोले वो बैंक का
38 में 10. ये 38 order.
चलना 38 with connected matters सीधे बात की साकल का सिद्धार्थ राजू
Yes. Yes.
This matter before the argument, the application for withdrawal of Makara those may be allowed. It is just for withdrawal of Makara.
Withdrawal of Wakalanama.
I have filed.
There is one application 5630. You want to withdraw on behalf of order number 6.
Yes, I would like in one petition for respondent number.
Any objection?
I obviously object to this kind of a situation. If my learned friend wants to withdraw for respondent number 6, he may withdraw. But the hearing must proceed in the light of the last order, which your lordships had passed on the 4th of April. If I may place before your lordships the 4th of April. Since 17th of January, we are doing this oscillation between respondent numbers 2, 5, and 6, seeking adjournments one after the other in sequence. I can show your lordships from every order in sequence. If your lordship sees 17th of January, the order dated 4th of April.
No, he is not seeking adjournment. He is saying that just allow his application. That's all. He is ready to argue.
Very well. Then we can
I'm
proceed.
holding
I
for
have no
Mr.
problem.
My lords, I'm holding for Mr. Devin Chauhan. He is before my lords, the interview of the senior designation. We have no problem if the petitioner argues now. He will address your lordships at 2:30, 2:15 if your lordships permit.
30, we already have a case listed for hearing.
I'm told that President Shah's information is that Mumbai, this resolution has come. This perhaps about 2 days ago. But otherwise, all of us are agreed to come in physically and finally argue the case.
So what do you propose then?
Argue the matter, but some time at 2:30. Ready to the matter.
You have instructions on behalf of Mr. Chauhan.
Yes, my lords. I have instructions that the petitioner may address your lordships right now. He will address your lordship at 2:15.
Okay, so we'll take up this case. अच्छा, 2 मिनट,
ईयर टी
2 मिनट.
पेपर बेंचेस भी
अच्छा. All right, so we'll how many new matters?
पेपर 45 है 38 का भी
So the first I went 2:15. The lordships have already kept some matter out.
No, at 2:15 we have 2 or 3 matters.
Some,
There's a bunch also, but then we can we'll rise for about 10 minutes, sit again, and then we can hear your case.
Very well.
Till 1:30. All right. We'll come back in 10 minutes. Yes. 8.1.
Lordships, I'm not able to hear the learned advocates on the advocate side. They need to be unmuted.
Is your mic mute? On. He's a very soft-spoken gentleman.
I know. Very, very kind anyways. But I'm still not able to hear him.
We have to be a little louder. Yeah.
I think I would see for definition of accounts of a partnership firm.
Yes.
Straight away take a lordship to be in order at a very short hour. That I to use reference has been. That order is at page 10.
What is the date of the order?
19th of July.
Yes.
A very short order. Not
14th of July or 14th of August 2023?
19th of July.
Except P1. P1. Achha, you're talking about the connected.
Connected.
So we are in the first case.
24/7.
All right. Stand corrected. 4758.
47.
Yes.
Yes. P1 19th of.
Yes.
current बाकी साठ नेक्स्ट चला रहा है दिनांक को बाकी कोई निर्देश के साथ 60 के समय प्रदान किया गया था कि बाकी 60 को किए जाने पर बाकी 60 का अवसर समाप्त किया जाएगा, परंतु आज दिनांक को भी बाकी 60 प्रस्तुत नहीं की गई है, फिर बाकी 60 प्रस्तुति का अवसर समाप्त किया जाएगा। इसी प्रकरण पर वादी द्वारा एक आवेदन अंतर्गत आदेश 18 को हर प्रक्रिया संहिता का चाहे 6 से चिन्हित किया गया आवेदन our main ground
Running in both of you are sitting.
19 July, just one day before previous date of the
Mr. Bajani, I hope you are able to hear the counsel on the petition.
Very faintly, Your Lordship. I've made an attempt to, try and hear. Very faintly. I only know that he's referring to the 19th July order at the moment. But I'll follow slowly. I don't want to take the proceedings.
Yes.
yes, main before 19th of July, not the matter was posted on 6th of July. Filed as to the page 63 and P5. What was that? P5 6th of July 20.
P5, yes.
Instead of taking a lordship to this very lengthy order, now my submission is that 4 locality applications were decided by this single order on 6th of July. 2 applications were applications for amendment in the written statement moved by different defendants. 1 application is for bringing additional documents on record by a defendant.
No, again, first was
2 applications are for amendment in written statement by 2 different defendants.
by 2 different defendants.
Yes. So these are 2 applications for amendment in the written statement. Then a third application was made an application for additional documents on record by another defendant. The 4th application was by this delegated petitioner himself seeking appointment of a receipt. These are the 4 applications that were decided by this order on 6th of July 20. All the applications have been taken up for consideration conjointly and decided by the council. Now we will see page 65, the first page, and the order begins. The application for appointment of receiver is taken up now. Thereafter, it is ultimately rejected. Then your office will just take page 78 of this the order. From page 78.
Yes.
The bottom your office will find by this order the application under order 6 rule 17, item number 2, filed by defendant number 2, application number 617, item number 3, filed by defendant number 7, and application number order 8 rule 183 CPC, item number 4, filed by the defendant 7 having decided. And then if your lordship will see this order further, a comprehensive amendment has been proposed by these defendants in their defense. That is my lord reproduced from page 80 onwards. These please regarding my lord the maintainability of the suit and certain facts have been proposed. All these amendments have been.
So both the amendment applications
Yes.
as well as
Documents.
taking documents.
Yes. All
Filed by
by the defendant. Have been ordered. 2 sets of amendments allowed and this additional documents allowed. My application for appointment of receiver, that's a different matter, but that has to be rejected by the same. And then lordships will come. Now let's see page 92.
yes.
92 laws must see the second last paragraph. It is that same order continuing.
Yeah.
Second last paragraph on an application IA number 5. Defendant number 4 argued that if plaintiff fails to produce evidence, then he will press upon such application and the opportunity of plaintiff's evidence, this application be kept in abeyance. Hence, it is not decided by this. Now, this IA number 5 is an application filed by defendant number 4 seeking her transposition from the defendant to the plaintiff. He says that she should be now transposed as plaintiff. So even this application had come up for consideration on that day.
That was filed by
Defendant number 4.
transposition.
As a plaintiff.
Right. Yes.
But it was taken up on that day. But then they made a statement that since the plaintiff has failed to lead evidence, in case the plaintiff fails to lead evidence, he will give a case number. So it was kept in. Then Lord the court said, looking to the circumstances of the case and a pendency since he has an early opportunity to produce evidence in such case, let the case be fixed for plaintiff's evidence with the direction of last opportunity for production of plaintiff's evidence, failing of the opportunity of plaintiff's evidence would be closed. Let the case be fixed with aforementioned directions for plaintiff's evidence on 19/7. 19/7 allows have seen that the right to produce evidence was given. Primary ground on which we have proposed production is that 6th of July. Very comprehensive amendments on behalf of defendants were permitted to be incorporated in the.
What is the nature of that amendment?
My lord lordship, I'll take it also. It goes to the root of the matter as far as their defense is concerned. It's a suit for dissolution and rendition of accounts of a partnership firm. The plaintiff has come to the court saying that all the other respondents, defendants, they are partners along with the plaintiff in a particular firm. It's the case of the plaintiff that the firm has not been dissolved, is still existing. Therefore, we praise to the court that initially the first decree is that a decree of dissolution be passed by the court to dissolve the firm. Thereafter, now the separate decree for rendering the accounts. This is his basic case. Now the defendants have come up with a different plea in the written statement. They say that this firm is already dissolved on a particular date. This is their difference. So plaintiff's cases now the partnership firm is a continuing running concern. Defendants have come up with a different plea when it has been dissolved earlier in point of time. And therefore, suit is not maintainable. Firm is already dissolved. It's also barred by time because they are making reference to an earlier date in point of time for such and such reasons. Also, sir, put a very pertinent question as to what is the nature of the amendments which were proposed. Now, kindly see that order for one moment, where the amendments are being considered. Now, this members will find the order P5 minor to page 78. Very short, I'll take your issues through what was proposed by them. Why we are taking by surprise, but we need to bring some consequential response to that. And prepare some time which to be given to the petitioner to prepare for this. Now, 70 at the bottom of the input applications are mentioned. At page 80, the court has reproduced the proposed amendment. Page 80 may kindly be seen.
Yes.
In that note, also we find that in subclause A, clause 70A, which they were proposing is quoted. I will just be permitted to read notes very short.
Yes.
Reading. Defendant number 2 submits that plaintiff has filed a company petition 58 of 2009 under so-and-so provision of the Companies Act. Entire area for investigation into the affairs of the company, rectification of register of members, claims, scheme, injection, appointment of administrator, special officer, auditor, and removal of operation and management for the Bangalore company against the defendant number 7, company and its directors. Defendant number 2 submits that paragraph number 45 of the company petition. The plaintiff admits that as per clause 10 of the partnership deed of 86, the parties had agreed that during the lifetime of Sri Parmanand Bhai Patel, so directed by Sri Parmanand Bhai Patel at his sole and unfettered discretion and after the death of Sri Parmanand Bhai Patel ipso facto, the firm shall stand dissolved, and said business of the firm shall be taken over by defendant number 7 company as a going concern. The defendant number 2 further suggests that plaintiff himself was director of defendant number 7 company. The business of the firm was taken over by defendant 7 company. Plaintiff was the director of the defendant number 7 company from 6 to 2017. Without admitting the contents of the company petition, the defendant number 2 submits that the plaintiff also reproduced and relied upon clause 10 of the partnership deed dated so in order to make out his case before the Honorable Company Law Board. Thus, the plaintiff admitted in his company petition that the firm should dissolve as per clause 10 of the partnership agreement. Copy of company petition, bearing company petition numbers also and not. Defendant who submits that defendant number 3 has addressed a letter on 25/3/2022 to him, which stated that Sri Parmanand Bhai Patel, his father, always intended that business of the firm be taken over by the company in 2000 and further intended the company to be established for a long term. Defendant number 2 submits that it is only because of such intention of Sri Parmanand Bhai Patel that the firm came to be dissolved in the year 2000 by him. A copy of the letter dated so-and-so along with Hindi translation is annexed to and not annexed to. Defendant number 2 submits is thus an admitted fact that firms to dissolve as per clause 10 of the partnership agreement of 1986. The plaintiff has conveniently chosen to suppress and conceal this fact regarding the pending proceedings before Honorable Company Law Board Mumbai. In fact, it was the duty of the plaintiff to point out such admitted facts in respect to proceedings before Honorable Company Law Board Mumbai. Defendant number 2 submits that it creates leave of this Honorable Court to place on record of this Honorable Court copy of documents supporting the aforesaid proposed pleadings and further claims leave to find the certified copy as and when required or granted by this Honorable. So this was the proposed amendment, but as I said, their defense that the firm had actually been dissolved prior in terms of time. This is a firm which the date of filing of this suit was already dissolved. Whatever facts they might have pleaded, not I am not going into the merits of that. That is not the stage here. But this is their defense. They say that some facts are admitted, some are have been concealed by the plaintiff, so they are not obvious in the document. Documents have been filed by them trying to support this facts. Then, I would say just bear with me on page 83. The other document by the plaintiff.
Which
83. 83.
yes.
Application number 617 in brief of this will be is in brief that the plaintiff has instructed the instance to the defendants for aforementioned relief as stated in suit. So defendant number 7 specifically pleaded that defendant number 1, that is the arrest firm, to dissolve in the year 2000 itself and is now not in existence, and the relationship as partners exists among the parties. And after the dissolution, business of the firm with all assets, liabilities, and right to use the goodwill of the firm was transferred to different 7. Company regarding which the Imran Shah constituted authorized agent sent a registered letter to the assistant registrar from the society Jabalpur with required documents. That the plaintiff himself was director of the defendant number 7, along with late Permanent Bhai Patel, Jyotsna Devi Patel, and Siddhartha Patel. That late Shri Permanent Bhai Patel sent a letter dated 7th February 2000 by which he addressed all the partners directing dissolution of the firm, that is defendant number 1, with effect from 31st March 2000, and also directed that the business of defendant number 1 shall be taken over by defendant number 7 with effect from 2000. At the relevant point of time, late Shri Permanent Bhai Patel was, now these are all actual. The crux is that they are bringing forward their defense to these pleadings forward that the suit has filed in frame the plaintiff has many concern. It needs to be dissolved by the defenses to form already stood before. And they are giving a specific date that somewhere in 2000 is acted. Therefore, they are further imaging that now shooting part of time essentially because there was a limitation of 3 years for from the date of the. So this is that. Now all this pleading, my lord, along with the supporting documents, what pursuant to this order of 6th of July 24. Now in the next date, subsequently, I have read out the last portion of this order. So again, my lord, at page 92.
Yes.
That there is no right reserved to the plaintiff to respond to this by way of any consequential amendment or documents are taken on record and pleadings are permitted to be proposed and allowed. Straight away, Lord, the matter is posted in that too with a peremptory direction. Like if I don't give my evidence on the next day, automatically the right is because there is no other business of the court to be around that. So this is the primary ground. So what we have seen is the order. Now there is another aspect.
And what about the earlier hearings?
Or one reason or the other might not be, there have been posted for recording and evidence. So there have been
There are about 6-7 hearings.
Yes, interlocutory
You got an opportunity to address.
There
You did.
these interlocutory applications are from clear dates. I don't say, my lord, that the case was never posted for evidence. It was posted on these dates.
Since when?
2016 perhaps is the first date noted by the court.
2016. That's almost what, 7 years? 6 years, 7 years. How long does the court wait for you?
Lord, I would not require any further time to my permission. That says this event happened that the people before application. I should have been given some time, one opportunity to respond to that either. To be of a consequential. Now, kindly see on the day when it was eventually posted on 19th of July, I have filed an application. E6 at page 94.
E6. The impugned order must have mentioned that application.
It does mention not, but the only thing is that it was first my right to evidence is closed and then this application is taken.
Application for
This is my lord under order 18.1. Essentially, the prayer is that I have filed a copy of the issue. I'll give an option to the issue.
That is P
P6.
P6. Yes.
This is on 19th of July. Next week. It's a very short application. You also put it.
Yes.
It is.
When was this filed?
It was on 19th itself. That's recorded in the order.
What happened to this? What was the fate of this item?
This application essentially, it was on a later date, not this. Reason being, my right to produce evidence has been closed from 19th. This application pertains to the stage of evidence itself. Who will now lead the evidence? This is an application, my lord, in which in para 3 we have said that the constitution of the partnership firm can be dependent number 1 is executed. So the fact that this firm had come into existence, that is not disputed. It is the stand of defendant number 2 and 7 that the said firm has already been dissolved. Therefore, the plaintiff is not entitled. Factum of dissolution is the pivotal issue in the present case, and the entire burden to prove the same lies on the said defendants number 2 and 7. The defendants 2 and 7 are therefore required to begin with their evidence of this issue, while the right of the plaintiff to rebut may be reserved together with the right to read evidence on other incidental issues. Plaintiff is abroad, and present application will be moved on telephonic instructions. A prayer was brought. It is therefore prayed that defendants 2 and 7 may kindly be directed to begin evidence on the issue of dissolution of partnership firm, reserving the right of plaintiff to debut and also to lead evidence of other issues of the proceedings. This was moved on the very next day. Application itself mentioned by that the plaintiff was not present in the country on that day. On his telephonic instruction, this application was filed that the primary issue in the case, as framed by the itself, however, just have issue P4.
Yes. Yes, sir.
What is P4?
Yes.
P4 not the first issue which has been framed. Whether the plaintiff number 1 partnership firm involved in the year. This issue has been framed specifically on the defense being taken by the defendants that partnership firm in fact already stood dissolved in the year. It is not the case of the plaintiff. He has come with a case that the firm is a life concern. It is continuing. Now, here, when the defendants had made a stand in the defense that the firm has already stood dissolved, so the first issue framed by the court, and in fact, not this issue is going to decide the entire. The firm has already stood dissolved in the year 2000. Definitely, all of the way in the mind will be what the modification will come and maintain. Every other issue, in fact, is dependent on this one, and this is raised by way of defense in the case.
Yes.
They can go to the extent of proving only the constitution, and that constitution of the firm is admitted. But admitted that it came into existence at some point of time.
Yes.
So therefore, once the court had fixed the case for evidence, the second ground is that an application under order between 1 and 3 was moved before. That this is the primary issue, and the burden to prove this issue lies entirely on the defendants who have raised this issue, because they have to prove this positive fact by leading evidence that it has actually got resolved on such and such date and by these proceedings and format.
Yes.
So on that day, my lord, that application is taken, but prior to that, my right to use evidence is also.
Yes.
So today, I am not on the merits of my application in the order.
Yes.
Because that has not been considered by the court at all. On a later date, in August, the matter was taken up. I was compelled to not press that application to withdraw it because it became infructuous. There was a plaintiff whose right to introduce evidence is closed, so there was no point in arguing on it.
Yes.
So my right is over. So on 9th of August, Another sheet is on record, I can point it out. When the matter came up, not I have got this application stating that.
Yes.
So this is also what had transpired on 19th of July. Just to show to the lordship, prima facie 18 rule 1 would be applicable at this stage. Hence the matter is fixed for evidence, and there is some weight to my prayer number 18 rule 1. This is one judgment. Paragraphs 11 to 16 of this judgment are available. But this way or that way, it would have been taken up for consideration, my lord. The matter was posted on 18.
All right.
Instead of straight away, my lord, the
Yes.
right to use evidence.
All right. Let us hear the other side.
My lord, am I audible, my lord?
Yes, Mr. Gulati.
No, my lord, I am Mr. Chauhan, my lord, I appear for respond number 2.
Yes, Mr. Chauhan.
Yes,
So should we start with which defendant should we start with?
my lord, I am the contesting respondent, my lord, the defendant in the suit, and I am respond number 2, Mr. Siddharth Patel, my lord.
All right.
So entire war, my lord, is actually against
Number 2 is defendant number.
defendant number 2, my lord. Similar pattern, my lord, as is in the suit.
All right. Yes.
My lord, I have very short submission so far as this is concerned. My friend also took your lordships to the other application which he had filed, my lord, by which he wanted us to lead an evidence before the trial court. I'll
Yes.
address that issue in a minute, my lord, but primary controversy before my lord was whether the exercise of jurisdiction by the trial court was so perverse that it would require interference by the court under Article 227 at this stage. So, principally, my lord is exercising jurisdiction under 227, the order being of a trial court. Now, whether that exercise of jurisdiction is absolutely perverse, my lord, which would require lordship's interference, is what lordship would have to be deciding at this stage now. Now, my lord must have seen my friend has already taken you through the dates, how this has happened, and what the trial court has done is, my lord, the trial court has painfully recorded that despite repeated chances being given to him, he chose not to lead evidence. And this is what the trial court, my lord, ultimately passed an order. Before that, my lord, please have a look at what now, therefore, my lord, we would be concentrating only on the order sheets of the trial court, how things proceeded before the trial court. And the order which is impugned before my lord is an extensive order and a longish order with complete reasonings, my lord, why it was required for the trial court to close his side. Now, if my lord may have a look at the order sheet which is annexed by my friend and which is also impugned here, which begins, my lord, at page 65. Whether, my lord, I am required to lead evidence or not is not, my lord, would be primarily deciding here. What lordship would be deciding is whether in the facts of this case, his right could have been closed or not, and what is the findings of the trial court. Now,
Yes.
I would not trouble my lord with the entire order. If my lord could straight away come to page 92 of the petition. 92, my lord. My lord has it?
Yes.
Page 92, bottom of the page, my lord.
Yes.
Looking to the circumstances of the case and pendency since 2012 and earlier opportunities to adduce evidence on 23/8/16, 14/8/18, 21/3/23, 14/2/23, 17/3/23, 25/4/23, let the case be fixed. Let the case be fixed for plaintiff's evidence with the direction of the last opportunity of production of plaintiff's evidence, failing of which opportunity of plaintiff evidence would be closed. Let the case be fixed for aforementioned directions, plaintiff evidence on 19/7/23. Now, this order would show, my lord, that the trial court has been waiting for the plaintiff to come and lead evidence not just yesterday or 2 days ago. The application for asking me to lead the evidence comes in a very later point of time. Therefore, my lord, if lordship must have noted the dates, since 2016 he was invited that, sir, please come. So it is not that only yesterday that the trial court thought it proper to close it, not even granting him in chance merit. Now, if Lordship would now see the impugned order, page 11. So last chance was given to him, Muller, yet again by recording what has transpired in the entire proceedings. And now Muller may turn to page 11, which is the order impugned. So Lordship will have to see the order impugned based on what has transpired in the earlier orders, which I have shown to my lord. Now see page 11, Muller. What happens yet again on page 11 after the last order which was passed and had showed to my lord?
Yes.
On 6/7/23 order we noted where the trial court was at pains to record everything, and page 11 he passes the order. Now let me see page 11. Prakaran Vadi, Mulad has it?
Yes.
प्रकरण वादी साक्ष्य हेतु दिनांक, अगेन ही रिकॉर्ड्स ऑल द डेट्स, नियत चला रहा है, परंतु वादी की ओर से साक्ष्य प्रस्तुत नहीं की गई। पूर्व नियत दिनांक को वादी को इस निर्देश के साथ साक्ष्य हेतु समय प्रदान किया गया था कि वादी साक्ष्य प्रस्तुत न किए जाने पर वादी साक्ष्य का अवसर समाप्त किया जाएगा, परंतु आज दिनांक को भी वादी द्वारा साक्ष्य प्रस्तुत नहीं किया गया, अतः वादी साक्ष्य प्रस्तुति का अवसर समाप्त किया जाता है। इसी प्रक्रम पर वादी द्वारा एक आवेदन अंतर्गत आदेश 18 नियम 1(2) व्यवहार प्रक्रिया संहिता के पेश किया गया, जिसे आय नंबर 6 किया गया था। आवेदन की प्रतिवादीगण को दी गई, तो हेतु दिनांक 27/1 को पेश हो। Now therefore, Mulad, after saying all this, the trial court closes the evidence, Mulad, and it is not that no chances were given to him. This is the only test which Mulad will have to be making into. This is the only inquiry which Mulad would be going into. Whether his right to lead evidence is closed in a slipshod manner, or Mulad, more than sufficient time was granted to him. My friend comes up and now says that I had filed an IA. I had filed an IA, and in the IA he should have first decided that. Now, what happens is this: I have filed reply in this petition. One order sheet, one more order sheet must take a note of. I do not know what is the paging of my reply filed by respondent number 2, and in which there is an order sheet. If my friends on the physically present can just point out the page number of the reply filed by respondent number 2 in the petition,
Annexure 3 to your reply.
Sir, thank you, sir. So Annexure 3 is one order sheet dated 9/8/2023, Mulad.
Yes.
Mulad has that? The order sheet of 9/8/23 annexed with the reply of respondent number 2.
Page number 9.
So therefore, it appears there is no continuous pagination, but Lordship may see the order sheet dated 9/8/2023. Mulad has it?
9/8. The paging is there, but you point out the page. The order sheet is
Mulad, it's the last page of my reply.
last year.
So
Part of P3.
yes,
document number
No, it's a separate document altogether. 247.
I'm so sorry, Mulad. I extremely sorry for this, but I do not have the pagination.
What is the date of the order sheet?
9/8/2023. There's only one document which is filed by R2. 9/8/23.
Last.
Lordship could trace it.
9/8/23.
That's right, Mulad. That's right. So a short order, just see in the middle of the order, Mulad. आवेदन पत्रक आए 6/23 पर वादी द्वारा प्रकट किया गया कि वादी साक्ष्य का अवसर समाप्त होने से उक्त आवेदन पत्र इनफ्रक्चुअस हो गया है, इसलिए वह बल नहीं देना चाहते हैं, अतः बल नहीं दिए जाने के कारण आवेदन पत्र निरस्त किया जाता है. So he not presses the application, brother, on 9/8/23.
Yeah.
And what Lordship would also find is no order sheet is placed on record which would say that you please first decide my application. That direction be given to the defendant number 2 to lead evidence, because the burden lies on him. Not even once that request comes before the trial court, that before deciding my application, before asking me to lead evidence, please direct them. There is no such request, at least to my knowledge, in the entire order sheet, Milord. None. Now, Milord, though it would ultimately Lordship's discretion to decide on the facts of this case. But now, please see, Milord.
This is page 9. Multiply 23. This is reply of respondent number 2.
Yes, ma'am.
One. This is in MP 4758. 4758.
Yes.
Connected one.
Yeah, you can.
In 4758, the plaintiff has come to the.
Yes, ma'am. 4758, plaintiff has come, whose right to lead evidence has been closed.
So in the connected case,
In the connected case, Milord, defendant number 4. Mr. Vijani, defendant number 4, correct?
3.
3.
I'm defendant number 3.
yes, please.
Yes, Milord. So the limited jurisdiction which my lord is exercising, Milord,
Yes.
would not invite interference in the conduct of the plaintiff, who himself has created a situation for the court to pass an order proceeding against him. Now, my lord, coming to the issue as regards the who would lead evidence first, that is not an issue which my lord would be deciding today. But in any case, my lord, I have also given one judgment of the Bombay High Court with my friend, my lord, there present, Shiv Lakshman Singh Palaskar, my lord. It's a Manupatra citation. But I'll try to have it there before, my lord, where it's, my lord, the Bombay High Court was very category that, my lord, it is the discretion of the defendant. There can't be a direction. My lord, got a copy of that Manupatra citation, my lord?
Yes, Shivaji Lakshman Palaskar.
That's right. Yes, sir. Justice Gugge's judgment, my lord. Lordship may come to paragraph 17. 17.
Can you give us the citation?
Sir, sir, this is a Manupatra citation, but there is an alternate citation written at the top. You can note that down, sir. 2019, Volume 3, Maharashtra Law Journal, 295.
Thank you.
Now, my lord, please see para 17. It is thus crystal clear that this court has my lord has got it.
Yes.
Yes. It is thus crystal clear that this court has concluded that Order 18, Rule 1 cannot be interpreted to mean that the court would be competent or would have the power to direct the defendant to enter the witness box before the plaintiff could do so. It cannot be ignored that Rule 1, Order 18 deals with the right to begin, and it is a creation of a statute that the plaintiff will have the right to begin. This right to begin can be altered only if the defendant makes a request to the trial court that he desires to begin. If the plaintiff does not oppose, the right to begin shall then vest in the defendant, and the plaintiff would thereafter lead evidence in rebuttal. If he notices that he is required to disprove a particular aspect, the judgment of this court in so-and-so was considered in so-and-so. However, in Sandeep Kedia, this court concluded Order 18, Rule 2 of the court is a clear provision, and it enables the trial court to pass an order on an application made by the plaintiff to direct defendant to lead evidence first. Though this court has observed in Order 18, Rule 2 was not considered by this court in Harian BD Supplier, that the Order 18 Rule 2 of the Civil Procedure Code directs the defendant to produce the evidence by the word shall, the interpretation by the learned advocate for the plaintiff in the case in hand, that this means that the court can direct the defendant to begin evidence first instead of plaintiff, and that too on the request of the plaintiff is unsustainable submission. I do not find from Order 18 Rule 2 that trial court can direct defendant to produce his evidence before the plaintiff could record his evidence, much less on an application made by the plaintiff that the defendant be directed to begin first. I do not find that this court has concluded in Sandeep Kedia that if the plaintiff makes an application to the trial court to direct the defendant to lead evidence first, the trial court can ignore Order 18 Rule 1 and pass an order on under Order 18 Rule 2 and grant defendant the right to begin first. Now, my lord, this has been the position. Though this is a Bombay judgment, my lord, we practice here, so it's handy for us. But this has been the law. Though this is not an issue before my lord today, but he can't take recourse to this and say that I was waiting for the trial court to pass an order on my application and therefore I did not lead evidence. Did he at any time make a request to the trial court, sir, my application is pending. Why are you fixing it for my evidence? Now, therefore, we say, sir, though Mr. Sanghi is there, my lord, he will show you one judgment of the Supreme Court regarding the jurisdiction of my lord's court. I need not dwell on it, my lord. But we say, my lord, no interference is called in this order.
Yes.
Grateful, my lord. I'm sorry for the morning time, my lord. I'm sorry to Mr. Vajani also, my lord. I was held up somewhere. So sorry. But we promised we'll go ahead. We have gone ahead, my lord.
Yes.
My learned friend need not apologize. I know what he was in for, and we wish him good luck for the thing.
So now it is for Mr. Vajani, and who else has to argue? You are for?
I'm for respondent number 5.
Mr. Vajani is for?
I'm for respondent number 3, your lordships. Original defendant number 4.
Since it's already 1:30, almost 1:30, we'll begin at 2:15.
Your lordships will take the special bench matter later.
No, of course, after the special bench. Special bench will take about 20 minutes, I think, at best.
Very well.
Pardon? Your flight departs at 3:45. You have to leave the High Court by what? What time latest? Then there'll hardly be any time.
There's no challenge, in fact, to the reasoning. The lordships around 6.6. There's no challenge to the reasoning of the trial.
Then we can hear Mr. Vajani later on and hear you first.
I have no objection to that.
Provided Mr. Vajani doesn't have an objection.
Mr. Vajani, I ensure to finish in 10 minutes. Not more than that.
I may take a little longer. I don't want to come in Mr. Sanghi's way. I know he has a flight, so let him complete whenever your lordships are convenient. I can address your lordships.
Thank you so much.
Deeply obliged.
No, special bench would be. That will take about 15 minutes. Can we record this tomorrow? We'll make it part hard and we'll you can connect virtually. Yes, please connect virtually tomorrow at 2:15. 2:15.
Your lordships, I have a partner at 2:30 in a different court. If your lordships may take it in the earlier part of the day, I have no objection. In the morning.
Can it be in the pre-lunch session?
Yeah, forenoon session. If your lordships may accommodate me.
Can it be 12 o'clock? 12 noon tomorrow. So we'll take it up at 12 noon.
Very well. Very well. Deeply obliged. Your lordship will keep the other petition also then at 12 noon.
We'll take it up tomorrow. Mr. Vajani will hear you also tomorrow.
Yes, very well. Very well.
And we'll hear you first at 12.
Grateful, Manoj.
We commencing 13.
OA has me. No, you must have filed the OA copy of the. That was P1, P2 क्या था? इसमें है commercial activity.
P6.
इसमें लिखिए that ये who was appearing for the other side? The main case. So Yadav was there. Is he there present in the court? आपके ओए में भी सफाई वाला ही लिखा है. That is the problem. How do we
Order was approved by the actually here was
have you served a copy on Mr. Yadav? No, Mr. Yadav was appearing last time. So it will be convenient for us that if notice is given to him. Mr. Yadav आए हैं क्या? अच्छा. कल लगाना पड़ेगा. All right, लिखिए इसमें the IF or IS also a modification of the order, final order passed and so and so. Filed on the ground that is filed with the prayer that the expression safai wala found in the said order, the modification in paragraph 3 and 6 be substituted with CCTC, commercial clerk, commercial cum typical. Next part. After having gone through the record, it appears that though the petitioner had wrongly mentioned the relevant post as Safai Wala in his OA, but the cause raised is pertaining to the appointment to the post of the CCTC. Next part. Therefore, this court deems it appropriate to modify the order under the review, the extent of substituting so CCTC in place of full form equivalence. Safai found in paragraph 3 and 6 of the order under review. Remaining part of the order shall remain intact, disposed of.
Even not more with corrected matter, he Siddhartha, Shukla.
Going for? April. Any interim order? As per क्या नाम आपका? हाँ? Ishan Tignat. On behalf of the petitioner prays for adjournment since the arguing counsel is on his legs before another court. Just after 2 weeks.
Here number 5, the Amit Kumar Chaurasia. Now the taking a month's time also. Honestly, already passed the month. 10 months in deliberately not comply.
Vikram Singh on behalf of the respondents. There is foreign is granted. How much time do you
A
want?
month's time.
4 weeks time to comply with the cost part.
Hey, in respect of the office,
File the compliance report. List after 4 weeks.
फाइनल
We'll take up, there are 4 or 5 more motions. We'll take up that and then come to your case.
Registration was required to be filed as files, along with all the requisite documents. You have to put in the process of conducting for any bulky record of appointment of over 11,000 candidates. Find free, don't take to file that registration. In fact, I have just kind of copied by the petitioner with them. And we are required to, as you also had, on the last day that a common to be filed, but we got a copy from them. We are required to.
We are also doing it at our end. Just some more time. No, as far as tabular, for as far as I'm concerned, Lord, it should be sanctioned. Therefore, for that tabular that we are making, but involved in the production done a lot of. Therefore, we wanted to be pitch perfect about it.
Can we dispose of all these cases and say that the judgment of the Supreme Court will be followed? That's all. You follow the Supreme Court judgment. We have not adjudicated anything. So you read it, understand it, and implement it. If somebody has a problem, will come to the court.
My lord, first, my lord, will be done. ID number 528. We have the last date of hearing, no reply has come. In that, Lord, I said that K.C. Nandan, Lord, and Rohit Chaudhary, both of them, my lord, have got appointment. So as far as their petition is concerned, that can be dismissed as having become infructuous. Because that is it. Because service matter PIL is not maintainable. And this is not a co-warrantor, nor is this the scope of co-warrantor. But co-warrantor is right after the appointment. My learned friends also know it very well. So Lord K.C. Nandan may be dismissed because I have not received reply to 5284. My lord was appreciating that argument of mine in the last case of hearing. I remember that there are only 2 petitioners in K.C. Nandan Sahu, and both of them have got appointment. Nothing remains in this petition. This petition may kindly be dismissed.
Lords, I appear for the petitioners in K.C. Nandan. If your lordships can just hear us for a minute. After the Supreme Court's order, which has been passed, which is dealing with the substance of, I'm sorry.
B.Ed holder, B.Ed not interveners in K.C. Nandan Sahu. So, Lord, I was saying as far as K.C. Nandan Sahu is concerned, because PIL is not maintainable, Lord, in service matters. And this is not a case of co-warrantor, nor is the scope of co-warrantor like this, my lord and my learned friends are well aware. All of us are practicing on service matter side. So, in that, therefore, only thing is that K.C. Nandan will have to be dismissed, provided you file a reply to 528.
Okay. We'll deal with that again later on.
Let that
but there is a request made by the state that there is more time for filing that table. Now, the suggestion of the court to the state is that since there is no question of any adjudication, because that has been done by the Supreme Court. So we will say that the state should follow the Supreme Court judgment.
That's
I
fine.
am for the selected candidates, my lord. We are all right with that. Let the state take a call, and because according to us, we are covered by that order completely.
Lords, that will have another round of litigation then, clearly from the positioning that is being taken. Because I can show to my lords that my lords have passed at least 3 interim orders saying that all appointments will be subject to the outcome of the final in the writ petition. Now, the Supreme Court's order, which has been passed.
Is it doubtful?
I beg your pardon, my lords, I couldn't hear.
Either you say it's ambiguous.
No,
it's not clear.
My lord, is absolutely crystal clear. It's only if the person who is appointed had filed a petition and got an interim order
that is not said.
Will not be. He will not.
I think Mr. Patwale has misunderstood the order.
Completely.
That's the whole intention
The
of the
thing is
order.
to read the order, my lords.
Yes.
There are only 2 conditions that are required. The first condition is that the person should have been appointed, a B.Ed candidate should have been appointed prior to the date of the Supreme Court's judgment. The second condition, if that B.Ed candidate wants to continue to have the protection, that B.Ed candidate should not have had his appointment made subject to any order of a court. In our case, as far as Madhya Pradesh is concerned, after the advertisements came, challenges were brought before this court, including in Kesri Nandan's case. Your lordships passed not one but two interim orders. The minute those interim orders were passed, the guillotine has fallen on all B.Ed candidates who wanted to take advantage of the NCTE notification.
That's a
That's all the
misreading of the order.
interpretation is.
The order
So
is very clear.
if we can
It
show your
says would be
lordships
subject
the
to final
order. We have
outcome.
filed a compilation.
It might have been
Mr.
instituted by
Patwale is
them.
for an intervener. I'm sorry. Can you allow me to complete? I'm the petitioner in the first lead matter. We have others have also intervened. Let me just argue on behalf of the petitioner. We have filed a small compilation, my lords, to put everything in one place to make it clear and simple. If your lordships can just take that.
We have to take it back to the department.
Yes, yes, we have placed it before the court.
There are 1,000 people, maybe 10,000 people. So how many will come back? Not more than 5%.
Absolutely right, Manoj. Let the state take a call as to what is
It will get opened up all over again. The idea behind the Supreme Court reviewing its own judgment and giving a final judgment was to ensure that nothing more will trickle up, my lords. I'm just suggesting your lordship may see your orders and the advertisements. That will put everything in the clear.
Lords, as per the state government in its affidavit filed before the Supreme Court, the dates of appointment are crystal clear. Those dates happen after the orders passed by my lords, including there was an impleadment filed by these candidates before the Supreme Court, and Supreme Court had itself in an order said that the all appointments or whatever in the pending proceedings will be subject to the outcome. So not only was this court, but there was also the Honorable Supreme Court's interim order there.
Can we just show you the Supreme Court's order, my lords? It's April. That's the only thing of which an interpretation is sought now.
Kesri Nandan and Rohit Chaudhary. So that petition should go, but why they are opposing, I have failed to understand.
So, we are dealing with the real issue. Your issue is not so real as the issue of let us say and let us take out the Supreme Court judgment and take out points, because we were hoping and expecting the state to assist us. But the state seems to be.
Therefore, we opened by submitting that on 15th of
Because there is no adjournment, no adjudication left now. There's no
The state has to come out with a stand as to what they are doing, and ultimately whoever is aggrieved can have redress against that.
Parties are directed to find a common
Well, if you take up the compilation which we have filed on behalf of the petitioner.
Only to assist the court. Now if the court does not need your assistance, you prevent the court from going ahead. Because the entire adjudication has been done by the Supreme Court.
Absolutely right.
We don't have to indulge into that.
We have received from
Well, there's no reason for the state to continue delaying like this.
That's fine. We'll deal with that as per we'll say that state government should implement the Supreme Court judgment.
But can we just draw one interpretation, because rather than open it up in future.
Make that clear. That is why I am repeatedly emphasizing my Supreme Court judgment deserves to be implemented.
My lords, may I make a submission here, if my lords may permit me?
Deserves to be implemented in respect of Vipin Kumar Dwivedi and all those advocates, my lord, who are representing the petitioner in Kesri Nandan have no right to address this court because nothing remains in their case.
So let us take up the Supreme Court.
Yes.
Let us take.
It's at page 20 of our compilation, my lords. In Kesri Nandan, in the lead matter, we filed a compilation.
24.
No, at page 20 of which
let them demonstrate
is order of 8th April 2024.
Mr. Rupra, we'll take up your case later. First, we'll take up the main issue.
The main issue, my lord, is in Vipin Kumar Dwivedi.
Where is that Supreme Court judgment? Where is that?
It's at Page 20 of our compilation.
That is the main judgment. KC Nandan is some PIL, which is not even maintainable, my lord.
We have filed a compilation in the lead matter in item 24, in which at page 20 is the order. It's order with April 2024.
In the first week of May, let it be heard finally, commencing from 1st of May.
We had sought your assistance. The court does not need your assistance, and our adjudication process is over by the Supreme Court. Now it is only that we have to just point out that what has to be done. That's how it is to be implemented. That is all.
Exactly, Manoj. That's all that needs to be done.
It will be general. It will be a generic kind of an order, direction that if this happens, please do this. If this happens, please do this. If this is the eventuality, do this. Otherwise, it is covered by the Supreme Court. Who goes out and who remains in service and who gets out. That is all to be identified. That's all.
It's an important issue.
Yes, sir.
There is a writ petition in the bank. The petitioners are appointed already. How can they maintain the writ petition? There are so many issues which have to be addressed before the Honorable High Court.
That we'll deal separately. We'll deal separately that Mr. Rupra's objection. We'll deal that separately.
So, therefore,
would your lordships have the court's order, Supreme Court's order?
We have already almost prepared it. I don't know why my friends are objecting to it. This matter is posted the first week of May. Let it be heard on any day. We commencing from 1st of May.
My lords, if we may see the history of this matter and the number of times the state has asked for an adjournment, on the contrary, in the last proceedings, my lords, this comment that the state is deliberately taking a position which it should not be.
Because she is in KC Nandan. Please first beat out these cases, not. One is KC Nandan.
Let's not get into locus standi now. There's a Supreme Court order at your behest.
A PIL has to be rejected at the outset, my lord.
The state of Madhya Pradesh has gone to the Supreme Court and got an order. That order has to be implemented. Can we just see that order now?
Either you say that PIL is maintainable, service matter, show me some Supreme Court ruling.
So I say this, my lords, let's put a quietus to this. There is Kesari Nandan and there is Vipin Kumar Dwivedi. There are two matters before my lords and they both are available for my lords for consideration.
I don't know why my friend keeps saying it's a public interest litigation. If he at least reads the papers of the writ petition, you will see it is a writ petition on behalf of DL-ed candidates. I don't know why it suddenly become a public interest litigation.
Because
this is obviously just a scheme to try and interrupt us when we are placing the order before the court.
It says, I read that the instant petition was filed challenging these notifications, whereby candidates possessing B.Ed were made eligible for post of primary school teachers. Petitioners also participated in the same process, holding the degree of DL-ed.
Precisely why it's not a public interest litigation.
For the post of primary school teachers in the same selection process, which they are challenging. The name of petitioner number 1
became a public interest.
Dated 4/4/2023 of District Anupur at serial number 225, that is filed here as annexure IA1. The name of petitioner number 2, Rohit Chaudhary, is mentioned at serial number 25 of select list dated 4/4/23, 4/4 IA number 2. Both the petitioners have joined on the basis of the said orders. Dated 4/4/23, IA1 and IA2, and are working in District Anupur and District Dhar respectively as primary school teachers since last about 1 year. Their employee ID has also been created.
My lords, may I make a submission to cut this short? There are two matters before my lords. Vipin Kumar Dwivedi and Kesari Nandan, my lords may hear us and then hear them later on that.
No. But
this,
they have no right to address the court.
I can't understand. That's for my lords to decide later on after we have put our case.
Or the B.Ed candidates go out of the court or not? How Lord Kesari Nandan or Rohit Chaudhary is going to be affected? That is a good question.
In fact,
Kesari Nandan can argue. Vipin Kumar Dwivedi are prepared to argue right now, but no counsel should buttress the case of Kesari Nandan and Rohit Chaudhary.
I will. I fully insist that I will.
First, kindly address on locus. Who are you?
Because Mr. Luthra should clarify whom is he appearing for. His intervention till date is not been allowed. Who is he? He's not a respondent in my matter. How can an intervener whose intervention is not allowed have the first audience at all?
It's allowed. Intervention is allowed. That was allowed long back. And right from the beginning, we have been insisting that this Kesri Nandan has been rendered infructuous because both the petitioners, they already have been appointed. And having participated in the same process of
Right, we are resolving the cases and we'll try to decide the cases. If it's difficult for us, then we'll release.
As the petitioner in the first matter, can I have 2 minutes?
If certain facts are evident from the pleadings, I think it should be evident from pleadings.
My lords, and in that Vipin Kumar Dwivedi, can I point out 3
Can we
orders?
make just 2 minutes of submissions on behalf of the petitioner? Just 2 minutes, that's all. It will not take more than 120 seconds. Yes, Manoj. It's simply this. If you look at the order of the Supreme Court, there are very clearly, it states, your lordships have seen the order, then I'm not going to trouble your lordships with it. But I'm just reading out 2 sentences from it, which is the relevant portion of it. It says that before us, 2 sets of parties are there. One set wants retention of the said judgment in its present form. The opposing side alleges that it would result in loss of employment to those who were already appointed as teachers in different states on the strength of their B.Ed degree. This B.Ed qualification was what was struck down by the Supreme Court. It is submitted that they had entered their employment following a legitimate course as per notification issued by respective appointing authorities, which did not stipulate.
Where are you reading in the order?
This is in the Supreme Court's order, page 5 of the Supreme Court's order, Manoj. It's page 24 of the compilation, if you have the compilation.
Yes.
It's at page 4. It's the bottom paragraph at page 4.
Yes.
So it makes it clear who the 2 sets are, Manoj. One who wants retention. The other who are those who have been appointed as with B.Ed qualification who don't want to be thrown out. That's the 2 sets. Now, after having considered all of this, if your lordships will come to the bottom of page 7, which is 26 of the compilation, bottom of page 7.
Yeah.
As it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on 11th August 23 shall have prospective operation. But, and this is what we are relying on, prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or conditions imposed by any court of law to the effect that their appointment would be subject to final outcome of the case, which might have had been instituted by them, and such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement. This is the second condition. Appointed pursuant to notice of advertisement where B.Ed was stipulated to be valid qualification. Yes. Services of only such candidates shall not be disturbed because of this judgment. We make it clear that this benefit is only for the candidates who were appointed. Please note, Manoj, appointed prior to the date our judgment was delivered, that is on 11th August 2023. Mere selection of such candidates or their participation in the process will not entitle them for a benefit under our present order. I'll just give your lordships the relevant dates, Manoj. The first advertisement that was issued was on 6th January 2020, after which we filed our writ petitions, Manoj, in which, and this is why the locus point keeps coming up, we asked for not only the striking down of the NCTE notification, but also that B.Ed candidates not be made eligible. Even in the future, if they are allowed to take part, it would affect us. The High Court passed interim orders dated. Please note these dates, Manoj. This is relevant because both these dates are before the Supreme Court's order. 7th July 22, your lordships passed an interim order. 7/7/22.
My learned friend is not here. I expect to never want to do it.
Pursuant to which some of these people went and intervened in the Supreme Court.
It does not survive, Lord. Why my learned friend is not addressing on locus, Lord?
After 7th July 22.
After he finishes,
surely I can complete what I'm saying, Manoj. Surely I can complete what I'm saying.
Now,
The first interim order is 7th July 22. The second interim order is 16th January 23. 7th July 22 and 16th January 2023. The order of the Supreme Court, the judgment of the Supreme Court, which is the cutoff date, is 11th August 2023. Now, of our friends who have been appointed, I'm sorry.
Taking your ownership to the judgment of the Honorable Supreme Court. Now, we are not quarreling on the issue that some judgment is pronounced by the Honorable Supreme Court, and it has to be implemented. There is no quarrel on this issue. But then the point is, how to address the Honorable
Lord, may I respond on the judgment of the Supreme Court?
I was just completing, my lords. I'll just take half a minute to complete now.
He's arguing in which case?
My lords,
I'll just take half a minute to complete, my lords. We had the same problem in the Supreme Court because people who are anxious to protect their jobs are obviously very anxious. I can understand that. I'm just stating the facts now.
Your clients, Mr. Shankar Narayanan,
Yes, my lords.
are diploma holders.
yes, my
Yes,
lords,
we are
both are
DLEd
clients.
holders. We are the only ones eligible for
They
these
have
posts.
been appointed. They have been appointed.
They've now been appointed. Now, yes.
All right. So,
No.
so they will not be adversely affected by the Supreme Court.
The B.Ed candidates who are senior to me, they are the ones who are going to affect me. All of them have to be out. If they, as per the Supreme Court's order, if they did not have the protection of an interim order,
Yes.
then it's a different matter. Here, there was interim orders which protected us, all of us as petitioners, and said that it would be subject to outcome. And those interim orders were passed prior to the cutoff date, which is 11th August 23. 2 interim orders were passed. And, my lords, the Supreme Court has said you must look at the dates of appointment.
That is evident from the record.
If I may now, if my friends 2 minutes are
Yes,
over, if I
we're
may.
just drawing your lordship's attention to 2 facts. 1, the dates of the interim orders.
This is what they did in the
2,
Supreme Court.
dates
They didn't
of
allow the other
actual
side to argue.
appointment.
We
The
go
dates of
through
actual
that. We go through the record, Mr. Shankar.
Lord, may I just have
Very well,
2 minutes?
then I won't
May I
say
just
anything
have
further.
2 minutes
My
from
lords,
the
can
other
I,
side?
before
Lord?
Mr.
Now,
Patwalia starts,
before
I
the
am for the
Supreme, just 1
petitioner.
minute, 1
Mr.
minute.
Patwalia,
They
I
are
am for
both
the
on the same side.
petitioner.
Please let me present the other picture.
My lords, can I appear for the petitioner and then Mr. Patwalia can argue?
Lord, they are both on the same side. So
My
let
lords,
me
that's not
present
the
the other
case. I
picture now
appear
that
in
one side
another
has been
matter and I
presented.
want to point different facts. Please do not do that, Mr. Patwalia. I appear in a different matter with different
This
facts.
is what happens.
You
Anyway, I'll
did
wait,
the
Lord.
same thing in the Supreme Court, not
I'll
allowing
wait.
anyone to argue. Please
I'll
don't
wait.
repeat it now.
Yes.
My lords, I'm going to be very short and crisp. I won't take longer than at least a couple of minutes. Now, my lords, can I just say one thing? The crux of the matter is the Supreme Court says the appointment had to be without any disqualification. The submission that we make before my lords is that in the writ petitions that were filed well before.
Lord, I have to make a point. Lord, I have to make a point. I'm on the other side. My point is this, Lord.
My lords, there are 4 interim orders. There are 4 interim
Lord,
orders.
let me make my point. Lord, that's what they want, that they should argue. Other side should not argue. Matter should be reserved. Now, the other side is, before the Supreme Court, there were 2 kinds of B.Ed candidates. One B.Ed candidate was where the candidate himself had gone to the Supreme Court because the state had declared him ineligible. Now, the other were where the state was declaring them eligible under the notification.
No, we have not filed any petition by them. That is the order.
Yes, I agree with my learned friend. Just kindly read one line of the Supreme Court order, my lord, which appears at internal page 8 of the Supreme Court order. Can your lordship take the bottom of the Supreme Court order from page 7? Just kindly have page 7 at the bottom. I'll read that paragraph. As it appears, your lordship has got that, my lord, as it appears?
Yes.
As it appears that a large number of candidates with B.Ed degrees had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it would be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench shall have prospective operation, but prospective operation of this judgment shall only be for those candidates who were appointed without any qualification or condition imposed by any court of law to the effect that their appointment would be subject to final outcome of the case which might have been instituted by them. Why? Because Rajasthan had declared B.Ed ineligible. In Rajasthan, the B.Ed candidate had gone to the court and wanted to appear. The B.Ed candidate appeared provisionally under orders of the court, even though he was not eligible as per the Rajasthan advertisement. Then he lost, and therefore he is ineligible. A similar position happened in Chhattisgarh. Chhattisgarh decided against the B.Ed candidate. There, the B.Ed candidate went to the Supreme Court and he appeared subject to result of the Supreme Court. So it is only where a B.Ed candidate had instituted a litigation and appeared on the basis of that interim order that he is not to get the benefit. Here are cases where we are people who are eligible under the state rule. The rule still holds valid up to today. We have been appointed.
Sorry, this is
Our appointment
completely
order
preposterous.
does not contain any condition that it is subject to anything. We have an absolute appointment letter in our favor. And the Supreme Court therefore says only if the B.Ed candidate has got some interim order and got appointment on the strength of that interim order, only then he is not to get the benefit of the judgment.
So,
That
my
is
lords,
the real
now may I
import.
respond
There
to
are-
this?
just
Now
one
may
minute.
I
There
respond to
are,
this?
my lord, there are
My
three
lords-
parts of the, just 1 minute, Meenakshi. There are three parts. If your lordship will see page 5, the para in the lower half of the page, there are three places where the Supreme Court says, if you are appointed, we will protect you. That is the underlying order. If your lordship will see para 5, bottom of the page. Before us, two sets of parties are there. One set wants retention of the judgment in its present form. The opposing side alleges it would result in loss of employment to those who are already appointed
That
as
way,
teachers in different states
My lords, may I
on the strength
respond?
of the B.Ed degree. Then again, my lord, 6 at the top, see what the court says, page 6 at the top. Now, having considered these factors, particularly the contention of B.Ed applicants that they have entered into employment as per the qualifying criteria specified by the appointing authority, equity should go in their favor. This line is very crucial when we read it with page 7. Those candidates who have been appointed because they were qualified as per the criteria of the appointing authority have all been protected. It is only those candidates who were not qualified as per the state criteria and who secured interim orders.
Mr. Patwalia, I hope I'm pronouncing your name correctly.
Yes, absolutely, my lord. Absolutely, I'm grateful.
That is also subject to certain conditions mentioned at page 7.
Correct. So
Yes.
let us read it, my lord, because it was hotly contested.
We'll clarify that 1, 2, 3, 4. If this happens, retain them. If this happens, don't retain.
Yes, because then your lordship will have to read the first 4 lines of page 8 very carefully, because any court of law that their appointment would be subject to final outcome of the case, which might have been instituted by them.
Manoj, in this
If the other
case,
side's interpretation is
candidates from
accepted,
UPTET
and
filed an
nobody is
application
saved.
in the Supreme
No,
Court.
this is not the object
Mr.
of the order.
Patwalia is not disclosing that.
The
On
object
11th of
of
October 2022,
just please don't
the
talk over
candidates
me.
from
You will
UPTET
have
filed an
time.
application in
Allow
the
me to
Supreme
finish.
Court.
Allow me to finish. Don't get anxious.
So at least take the right
Now
facts.
the point is,
Mr. Patwalia, please finish.
yes. So, my lord, I am only saying, my lord, the underlying object of this order at 4 places is anybody who has secured appointment should be protected if he is qualified as per the state government regulation. It is only if you have secured an appointment when you are not qualified as per the state government's rules by securing an interim order that you are not protected, is my respectful submission.
My lords, may I
And
just
my
have
second
by the
respectful
clock?
submission is,
By the
if
clock,
this
my
interpretation
lords.
is not the correct one, then this order protects nobody. Then everybody goes, because everybody who is there was all subject to some writ or the other, and therefore this order
Yes, my
becomes
lords, let us now
completely odious.
let us look at what has transpired here. 1 minute now,
my
Mr.
lord, also
Patwalia. I think
Calcutta High Court, in fact, has also passed an order.
Mr. Patwalia, let Ms. Arora also.
my lords,
make
just
One
few
last
minutes,
line,
and
one
I'll be
last
very,
line.
very quick
The
with this.
Calcutta High Court has passed an order on 19th, and the Calcutta High Court has said exactly what your lordship said when the hearing opened, that Supreme Court has decided the state government is to take action strictly as per the Supreme Court order.
Please give us the
So,
copy.
my lords,
Mr. Siddharth Shukla will have the order, my lord. Mr. Shukla can pass on to your lordship
so,
that order.
so my lords, now where the state is
If your
making a
lordship, just one
submission
line,
and
one
Mr.
line.
Patwalia is saying that, I think there is a need on how my lords will pass this order. May I just show very, very quickly few pages which I say is completely the Supreme Court order when it cannot be applied in respect of B.Ed candidates who have been appointed when my Lord's direction to the state were already in place that appointments, if any made, will be subject to the final outcome. The first order that my Lords passed was on 7th of July 2022. My Lords, the date is very important. My Lords will find this at page number 1 and 2 of my Lord's compilation, to which Mr. Gopal Shankar Narayan was referring to. My Lords, on 7th July 2022, on this date, no appointments had been made, but if any appointment, I take it, had been made, will be protected by Supreme Court order, but after this, definitely not. My Lords, after this court passed an order on 7 July 2022, and the relevant parties, recruitments in question and any appointment made shall remain subject to final outcome of this petition. My Lords will find it at page number 2 of this particular compilation. Now, my Lords, what happens is that on 11th October 2022, B.Ed candidates file an application before the Supreme Court for intervention. The matter comes up on 12th October 2022. Yes, for impleadment. And my Lords, the matter comes up on 12th October 2022. The office report notes that this application was before the Supreme Court on that date. Please turn to page number 7 of this compilation and please see the order passed by the Supreme Court on 12th October 2022. And it says, my Lords, any steps taken during the pendency of these proceedings having impact on the controversy out of which these proceedings arise shall be subject to the final outcome or any further order that may be passed in this matter. Now, B.Ed candidates have approached through an impleadment, and this is an order that is passed by the Honorable Supreme Court. Now, my Lords, the first advertisement thereafter of the state comes on 19th October and 16th of November. And my Lords, another advertisement comes up on 26th of November. The writ petition is filed before the Madhya Pradesh High Court, and Madhya Pradesh High Court by an order of 16th January 2023. All these orders are prior to these appointments. My Lords, please turn to page number 8 of the convenience. Now, please turn to page number 8. This is not now Keshri Nandan, this is in Vipin Kumar Dwivedi. In this petition, the court says, all further actions by respondents will be subject to further orders of this court. My Lords, the way Madhya Pradesh government has been going, my Lords should see, because there's a direction to them and they are aware that they can't make these appointments. Now, my Lords, what happens is that the appointments for the first note advertisement, which is 19th October 22 and 16 November 2022, happened between 30th of March 2023, which is after my Lord's order of 16 January 2023, to between 15th of April 2023. Would my Lords be so kind and turn to the affidavit filed by the state of Madhya Pradesh before the Supreme Court? My Lords will find this affidavit at page number 12, and the categorical statement made by state of MP is at page number 16.
All this has to be now going by the final
1
order.
minute now, Mr. Patwalia, you've had your say.
It has to follow all appointments
Yes,
which have been made
now,
on petitions not filed by
Mr.
us.
Patwalia,
Will have to be
please
saved.
don't obfuscate the other side from presenting their case. You have said, please allow me now. Now, my Lords, this is an affidavit filed by state of MP. Please come to page number 16. And this is very, very important. It says, my Lords, in the second paragraph, first of all, there were total of 21,962 appointments, out of which 11,583 were given to the B.Ed. Now, what are the dates on which they have been given? Please look at the tabular chart below. 30th of March 2023, a total of 16,000, out of which 8,799 were B.Ed. 10th of August, my Lords, 1 day before the judgment. 1 day before the judgment, and I say this, my Lords, this is very unusual.
Who would know
Let
when
me
the
call it
judgment is
unusual.
coming? This
Yes.
is just
Lords,
creating
we
doubts
all
for
know.
nothing.
Mr. Patwalia, you've had your say. Please now rein your horses. Now, my Lords, on 10th of August 2023, 5,617 appointments, out of which 2,784 to B.Ed. Now, all these appointments are post orders of my Lords of 7th July 2022 and 16 January 2023, including the Supreme Court order of 12th of October 2022. My lords, I submit with complete humility when the court at page number 7 of its order, the Supreme Court, which my lord saw just now, at page number 27, bottom of page 26, 27, please read it now in that perspective. What has happened here? Once these orders had been passed, these appointments were all subject to the outcome. Today, the outcome is clear. The Honorable Supreme Court has held B.Ed is not an eligible qualification for the purpose of appointment to the post of primary teacher. The eligible qualification is D.Led. The only thing the court has said that if you had been appointed without any restriction or disqualification by any order of any court, my lords, that's page number 27. My lords just saw that. Only then you may be protected. Here, clearly, there was an order of my lords which put a disqualification that these appointments will be subject to the outcome of these petitions. My lords, the second thing that I most humbly submit to you is this. My lords, so far as the D.Led are concerned, for them, the only appointments can be for the primary school. So far as the B.Ed is concerned, the scope is much wider. And that is what has been noticed also by the court in Divesh Sharma. Now, if we are entitled to only these limited vacancies and have no other opportunities, while B.Ed have still a much larger area open to them for appointment, there is no reason why, my lords, those of us who are eligible, qualified, should not be given these appointments. And I most humbly submit that today, in view of the Divesh Sharma judgment of my lords 11th August 2023, and including this clarification, the present appointments which as per state have been made on 30th of March 2023 and 10th of August 2023 are in teeth of that particular order of the Honorable Supreme Court. And my lords orders, the two orders that I have shown, 7 July, 16 January 2023, 7 July 2022, and Supreme Court interim order of 12th October 2023. My lords,
I can respond. It is, again, they have glossed over the words at page 8. They have been glossing over those words. Those words are crucial, that their appointment will be subject to final outcome of the case which might have been instituted by them. Supreme Court is crystal clear in saying so.
This is hair splitting, my lords.
Otherwise, Lord, nothing will be saved. Otherwise, this clarification is meaningless.
Mr. Patwalia, I think we have heard you.
All right, grateful. I'm sorry.
Otherwise, this process is going to become unending.
I'm sorry.
Every lawyer is going to respond to every sentence.
I'm sorry.
So,
well, on facts, can I just take 10 seconds? Just 10 seconds only on facts, not more than 10 seconds.
He's assisting her first.
Just 1 second, sir. The Honorable Uttarakhand High Court has followed the same retrospective application, and the Supreme Court dismissed the SLP, saying that whoever has been appointed post the interim order has to be out. Recently, the Honorable Supreme Court on 5th April 2024 has dismissed the SLP filed by the B.Ed candidates. That's number 1. Where the Uttarakhand
that was before the clarification.
1 second,
please
sir.
tell them
Sir,
that is before the clarification.
If you don't mind, sir, please, if you don't mind, please. The Honorable Uttarakhand High Court has followed retrospective application wherein interim order, any appointment post that, out. Number 2, my lords, the Honorable Chhattisgarh High Court has again followed the same principle of law, where they say that any appointment post an interim order will not succeed in case they have been appointed post that interim order. So, my lords, when multiple high courts have been following, and if my lords would want, we'll put that in the written submissions, not more than 5 pages, we'll put all of that, and how all the high courts across the country have thrown all the B.Ed candidates out where they have been appointed subject to an interim order passed by the Honorable respective High Court. That's all.
In those cases, I am told applications are being filed for recall because of this clarification. Those are all prior to clarification.
Today, there is no recall.
I hope the council appearing virtually have concluded.
Yes, ma'am. Yes.
We are grateful, Mr.
We are extremely grateful. Very kind.
We will get a chance. We are very sure. After all these people come to the verbal hearing, and also like to address because of them have not. Let them address, Lord, we are silent. After that, my learned advocate general is also there. After that, हम लोग को चांस देंगे.
Yes. Yes.
Lord, please see. Admittedly, the advertisement was issued once, the first advertisement which was issued.
I think the learned advocate general has the right to first audience. First audience, yes.
Definitely.
Firstly, the lordship can kindly see. There are uh, 5 writ petitions in which it is said whether the interim order was passed. So, your lordship can kindly see WP number 13768 of 2022.
There was an interim order, yes.
The interim order was passed on 7th of July 2020.
Yes.
Now we are raising serious objection with regard to maintainability of this writ petition. Because the petitioner willing, they have already been selected and appointed. But this writ petition has rendered infructuous. Now the second writ petition is WP 595 of 2023.
Yes.
In this matter, my lord, the judgment from Honorable Supreme Court came on 11th of August 2023.
No, there was IR in this case.
IR was passed on 28th of August 2023. Subsequent to the order passed by the Honorable Supreme Court.
IR is dated is.
WP 595 of 2023 within Kumar Vedi.
28/8/23.
Yes, and the order of the Honorable Supreme Court is dated 11th of August 2020.
Yes.
So here, while the appointments are not going to be disturbed in this writ petition, the another writ petition is WP number 21800 of 2023. Another one. In this matter, interim order was passed on 14th of September 2023.
Yes.
Similarly, in WP number 2218 of 2023, the interim order passed by your lordship on 21st of September 2023.
Yes.
And then finally, in WP number 29809 of 2023, Vivek Pandey. Now, in this matter, the interim order was passed on 15th of December 2020.
December 23.
Yes, yes. Now, my respectful submission is,
yes.
In the light of the judgment pronounced by Honorable Supreme Court and the condition imposed therein, the appointee in WP number 595, WP number 21800, WP number 2218, and 29809, they are not going to be disturbed. There is no appointment order will be disturbed, manner if we implement the directions of the Honorable Supreme Court, because it has been given prospective operation manner, and prior to passing of the judgment by the Honorable Supreme Court, there was no interim order passed by your lordship. Now there is only one writ petition which is left. Is Kesari Nandan Sahu's matter now. And in that writ petition,
yes,
but the appointment has already been granted to the petitioner.
Yes.
So they came before your lordship. But then they could not take up the selection process. Because they have raised grievance with regard to the selection process undertaken by the candidates and the initiated by the state government. And subsequently, these petitioners, they are appointed. Now we are, my learned friend Mr. Rupa and my learned friend Mr. Gindia, but all them are raising, interveners are raising objections that they cannot maintain their petition. Now the issue to be taken into consideration before your lordship is, once the writ petition goes on this objection that it is not maintainable, but the interim order which was passed on 7th of July 2022 in that writ petition would also pass in the final order. Therefore, my lord, we have raised this objection, and that objection needs to be addressed. Now, while learned friends who are appearing in that particular, instead of addressing your lordship and assisting your lordship on this material issue, they are taking your lordship to the judgment pronounced by the Honorable Supreme Court. So even we are saying the judgment which is passed by the Honorable Supreme Court that has to be implemented. Yes.
And what about the remaining cases?
No, in the remaining matters, there are in most of the cases, notices are also not even issued. And no interim orders there.
That is 24.5 to 24.10.
सब कुछ में in few matters notices are in fact the notices are also not issued in these in 5-6 repeats. So what I am respectfully submitting your lordship may kindly appreciate. The interim order which was passed.
So in 24.5 there is no interim. Now let us see 24.6.
Your lordship may kindly appreciate. I have referred the number of writ petitions. There are only 5 writ petitions in which the interim order was passed by your lordship. Out of which there are 4 writ petitions in which interim order was passed subsequent to the pronouncement of judgment by the Supreme Court.
Yes.
Now, in one of the matters, in that particular interim order was passed on 7th of July 2022. That is much before the judgment date of pronouncement of judgment by the Supreme Court. And in that matter, we have raised this objection that writ petition is not maintained. The petitioners are appointed. They have no grievance. And they maintain their writ petition before your lordship. Therefore, one of these need to address of this material issue. How they are submitted that there are several appointees who are having qualification of B.Ed. Whether it is speeded in the writ petition, whether they have raised any grievance with respect to this category of candidates who have taken up the selection process and ultimately appointed by the state. So all these things are required to be seen, and therefore, the objection which we have made to go to the roots of the matter, they cannot maintain that writ petition, and therefore, I am making a more humble submission that this objection which we have raised, many friends have raised, they are required to address and assist your lordship on this issue. And once your lordship is satisfied, yes, then their writ petition, then whatever direction which your lordship will pass, will bow down to it.
That is the first case.
And those maybe respond.
Only in the case of
no, my lords, also Vipin, also in the case of Vipin Kumar Dwivedi, order was passed on 16th of January 2023. The prayers made in all these petitions are broad and wide, in fact, asking that B.Ed are not qualified at all. And my lord said that appointments, if any, will be subject to further orders of this court. It is at page number 8 of that compilation. That is 16th January 2023. The prayers are wide and they are across board, my lords. So it can't be said that it applies only to the petitioners therein and not to other people who will be affected by it. I don't think that may be a right submission at all to make in matters of this nature, where there is a challenge to that very policy, the qualification itself, which has been struck down. And we cannot lose sight of the fact that by this time, Rajasthan High Court had actually struck down that qualification of B.Ed. The judgment of Rajasthan High Court pronouncing it in rem was already there. And be that as it may, nevertheless, if the state of Madhya Pradesh took a position, appointed people, cognizant of the fact that B.Ed is not a qualification struck down by Rajasthan High Court, Supreme Court says it is subject to the outcome of the proceedings. This Honorable Court, again on 16 January 2023, well before the appointments that took place on 30th of March 2023, said all further actions by respondents will be subject to further orders of this court. So those appointments are all with qualification.
Let us hear the counsel for the petitioner and Kesri Nandan. Yes, please.
That is Mr. Gopal Shankar Narayan was appearing.
Well, I'll assist Mr. Shankarayan who is just joining. Allows may have that compilation that we have submitted. We have produced the prayers in the Kesri Nandan matter, which may be relevant. to address on the fact that whether the petition is maintainable or not maintainable. Allows me kindly have that compilation for a minute.
Mr. Kalra, Mr. Chakin is here to represent Kesri Nandan Sahu and another. Let him argue first. Yes. Huh?
Arguments of the
Shankar Narayanan is not there on
He's
screen.
just joining in 2 minutes, my lords. If my lords would permit, I will assist till the time he joins. In case South's matter.
Who is the petition now maintained?
I have challenged the legality and validity of the MP Rule 2018 as well as the notification issued by the NCT, including the advertisement issued by the DBRAU.
Let's take out your petition. Yes.
My lords, for the ease of this court, the Kesri Nandan Sahu prayers are already there in that convenience. If that is what my lords are looking, that's only to assist my lords. And my colleague is here already anyway.
What is the prayer?
Yes, my lords.
apologies.
My lords, the prayers in Kesri Nandan Sahu, my lords will find at page number 2 of that small compilation itself, where the petition and the prayers are set out in second column.
Mr. Arora, let Mr. Thakur.
Yes, absolutely. Let Mr. Shankar Narayan take over. We were only assisting, my lords, in the interaction.
My lords, if you can just see the prayer in our writ petition. We have set it out in our compilation also at page 2. Do my lords have that? Do your lords have the compilation we had submitted?
Prayer clause in front of me. Yes. No, I have the petition in front of me. Prayer clause is there in front of me.
Yeah, prayer clause. So if I can just read that. The first prayer concerns the NCT notification. Now that has been decided by the Supreme Court. Finally, they have struck down the notification which had provided for B.Ed to be a qualification. The second, and this notification was the one that provided for the B.Ed candidates to have the eligibility. The second prayer, that the Honorable Court may kindly be pleased to issue a writ not to treat B.Ed candidates as eligible for the post of so-and-so without passing NCTE prescribed bridge course. If I may pause here for a minute. The minute they have treated B.Ed candidates, they have appointed B.Ed candidates, and those B.Ed candidates get a preference over me, I am affected even if I am appointed. The simple fact of my appointment doesn't take the wind out of my sails completely, as my friend is choosing to argue. I have an issue with ineligible candidates coming in who will at later stages make claims regarding any avenues of progression that I would have, which is why it's very much maintainable by me saying that you do not have a legal qualification to be here in the same cohort as me. That is my argument.
We are raising an issue which is not here before us, and the issue is of seniority among
I'm sorry. It's a question of eligibility, Manoj. It's a question of eligibility. I'm saying if the entirety of the NCT, I'm sorry, I shouldn't have interrupted. I'm sorry.
You are raising the issue of inter-se seniority between the DLED appointees and the B.Ed appointees whose appointment has now been saved by the Supreme Court. Now that issue was never there. So
it wasn't, and I'm not raising that. I'm not raising that. Let me just clarify what I am raising. I am raising the fact that there's no question of inter-se seniority if the other person doesn't exist. The other person who is a B.Ed candidate, the Supreme Court has made it very clear that since petitions were filed and interim orders were passed, which is the virtue of which you are allowed to continue, you will not have the protection. So the B.Ed candidates go out completely. My issue is with the B.Ed candidates remaining in the room. That's my problem. They cannot be eligible at all. And that is why I was here in the Supreme Court as well, arguing this very issue before the Supreme Court. There was no objection taken to my locus standi here. I'm very surprised that somebody is taking it now in the High Court.
Despite having a B.Ed,
Yes.
who have been appointed and saved by the Supreme Court, the appointments are valid now. Subject to satisfying those conditions in the Supreme Court.
Correct. So if they have not if they were not appointed prior to the judgment, appointed on the 10th of August, in fact, the day before the Supreme Court judgment, the notifications have been issued by the Madhya Pradesh government intending to appoint them, but not actually appointing them. That's a very important distinction to be borne in mind. There are two swaths of appointments that have taken place in Madhya Pradesh. One on an earlier date, and the second the day before the judgment, which is a remarkable coincidence. I'm sorry, between 30th March and 15th April, there were appointments carried out. But then on 10th August, they claimed that there were some more notifications issued, but not appointments made. Appointments are all made after the judgment. So they would not be saved either. As far as the interim orders are concerned, the interim orders are applied across the board to everybody. As a result of which, no B.Ed candidate in Madhya Pradesh can make a claim. Right. I may point out that when the first interim order was passed, your lordships took note of the Rajasthan High Court judgment, the judgment that was sustained by the Supreme Court on the main matter. That was taken note of. I may also tell you that after your first interim order, these very interveners came to the Supreme Court, filed an application for intervention as well in the main matter. And yet the judgment came. So it binds them all down. I'm grateful.
Yes, please. But the interim order dated Sula 8
Yes. Bola.
16
595 is 15 January. Yes.
also the interim order, all the further action by the respondent will be subject to other law.
Yes.
Similarly, one set of petition, KC Nandan and
सोलह एक तेईस का जो ठाकुर साहब बता रहे हैं आपको इसमें उसको फिर क्लियर किया था 28/8 को भी देखना होगा इंटरव्यू ऑर्डर उसी में नहीं बनता है उसको थोड़ा हुआ है 28/8 को फिर क्लैरिफाई किया कि अपॉइंटमेंट सब्जेक्ट टू आउटकम रहे इनिशियल में दैट वाज नॉट द डायरेक्शन
dealing in length without this order is also
repeated directions are not passed by the honorable court. It is only when by the initial order which was passed on 16th of January 2000.
If you see the 16(1) order, it's of a very generic nature. It covers everything. Further action by the respondents will be subject. Further action means recruitment plus appointment.
Your lordship may kindly see the subsequent interim order. On 28th of August 23, in the same writ petition.
Yes, yes.
Was the intent of the honorable court that the appointment shall be disturbed, but the subsequent interim order can be found by the court. But then, my lord, specifically, the court was kind enough to direct that no further appointment shall be made. And this, the order was passed on 28th of August 2023.
Yes.
Now, the electorate cannot skip this order and refer the initial order in which this honorable court never directed that the appointment order shall be kept subject to final order. Yes. So, my lord, both the interim orders are required to be seen.
Yes.
I'll be surprised, my lord, that my learned friend will say that repeated interim orders are required to be passed by the honorable court. My lord, I have not seen in my life, my lord, that repeated interim directions of similar same nature is passed. Once the interim protection is granted, end of the matter. It is there, but because there was no intention of the honorable court. To keep the appointments subject to final outcome, and therefore subsequently on 28th of August 2023, my lord has specifically directed. Now keep all the appointments subject to final outcome of it.
That we have noted, yes.
Now, Manoj, please. Manoj, can you?
Have you completed? May I please talk about Kesari Nandan only. Your counsel in all petitions. So what remains in Kesari Nandan now? The relief that you have sought has been granted. What other relief you have?
The appointment.
Then what are you claiming? Yes.
I have challenged only the validity of the rule of the state government published in July 28.
Which rule? Where is that? Where is that challenge in the prayer form?
Para 7.5, Manoj, at page 30 is the challenge to the rule. Para 7.5, page 30.
With advertisement data, 61/2022, contended and 51. Only to the extent of Madhya Pradesh primary teachers eligibility test 2023. Restraining the B.Ed degree holders candidate for appointment on the post of primary teacher, school teacher, and to give appointment only to those who are D.Ed diploma holders candidate.
This is already granted to you by the Supreme Court. Granted हो गया ना ये तो. They have said that DLED is the prescribed qualifications. And so far as B.Ed appointees are concerned, they have passed certain orders protecting some appointments, not protecting some, subject to certain conditions. Are we going to sit over the Supreme Court? Then Supreme Court has decided that case. Supreme Court has upheld the Rajasthan High Court order. Rajasthan High Court quashed the notifications. And this order of the Supreme Court also covers all other cases mentioned, I think, in the last paragraph.
All other states also. It covers all states.
It is clear that directions contained in the order shall not be confined to the applicant, state only, and shall cover all cases which may be pending in different judicial fora in any state or union territory on the same point of view. What remains now? Anything else? Who? Well, there are only two petitioners there in this petition.
And
Which petition? In which case?
Point one, Will Kumar Dwivedi, they have not appointed. And Tarun Agarwal, there is, and petitioner, they are also not appointed.
So this Vipin Kumar Dwivedi, what diploma holder or?
Diploma holder.
Diploma holder.
Manish Sen, they also not got appointment. On the petitioner of diploma about the unit.
There are two petitions. Same petition.
Yes.
The prayer are same or different? Same. Copy paste.
My lords, it will be fortunate if they are copy paste because then they are wide in nature and they are then in rem. So even one petition will cover the relief for everyone else who's similarly situated.
All the parties were directed to act in strict compliance of the law. It's a past matters of that will serve the purpose of the protection of funds. If you have option, sometimes it's ordered.
That is exactly what I had said in the beginning.
Yes,
That-
yes, but there's something about that direction.
So let the state government, let the state government implement. If there's any folly in the implementation process, they'll come back to it.
Yes.
My lords, with that, I think it's a writing on the wall. If my lords have heard the argument of the learned AG, my lords, then it's a writing on the wall. My lords, the learned AG has in no uncertain terms suggested a particular position and which I guess will be the position of the state. I would request my lords to my lords.
Also argue. Yes, yes, Mr. Devi.
My lords, please see. My lords, notice few dates. So this advertisement is issued on 6/1/2020. Why I am drawing the attention of the lordship, I relate it to the order passed by the Supreme Court.
No, Mr. Gilia, you are appearing for?
I am appearing in K.C. Nandan as well as this Vipin Kumar, we earlier made filed intervention application. Our applications are allowed, we are included as respondent.
You are B.Ed appointees.
No,
Yes.
Now, my lords, kindly notice, the advertisement is issued on 6/1/2020.
Yes.
The examination is held on 5/3/2020. 5/3/2020.
After more than 2 years.
Yes.
This is a written exam.
But this was delayed due to COVID and all of the certain examination.
All right.
Then, my lords, this petition was filed on 13/6/2022. K.C. Nandan's petition.
13/6.
2022. And it was filed by these petitioners who had already participated in the process of selection. They went by the conditions of the advertisement, participated in the process, and thereafter they filed this petition on 13/6/2022. The interim order was passed on 7/7/2022.
Yes.
During pendency of the petition, both the petitioners got selected and appointed.
When was that?
Well, their appointment orders are 6 Well,
The appointment orders.
both are appointed. Well, we had supplied the copies of their appointments. I'll just give the dates. 4/4/20. 4/4/23.
Both. Same date.
Yes. They both were appointed.
Yes.
Now, can you see the relief clause words, which Manox have just seen, relief clause in the report? Because it has been said that their grievance still subsists. Now, how it subsists, Manox is relief. 7.1 is Manox that relief they have already got. As per as Manox 7.1 is concerned, that NCT regulations Manox that has already been declared Manox. Now, can we see 7.2? That the Honorable Court may kindly be pleased to issue an appropriate writ order or direction not to choose B.Ed candidates eligible for the post of primary level teacher in schools under RTE Act 2009 without passing NCT prescribed this course before appearing in TET examination. This relief has already been granted, and the B.Ed candidates have been held ineligible prospectively. The appointment management kindly noted that The appointments of the B.Ed candidates who have already been appointed, subject to the condition imposed by the Supreme Court, their appointments have been protected. And it is held to be ineligible for only prospect. Now, relief 3. That the Honorable Court may kindly please to grant liberty to the state government to treat only VSTC candidates as eligible for appointment on the post of primary teacher on account of availability of adequate number of such trained teacher, or to give them preference and weightage in the selection process of primary level teachers above such B.Ed teachers who are not possessing adequate training and qualification for working as primary teacher to teach students in class 1-2. This related also becomes instructors with their appointment. Now, next, to this Honorable Court may kindly be pleased to the extent that the same relief to the present petitioner has been granted by Honorable Rajasthan. This has also become important. That the Rajasthan High Court has declared the NCT regulation as illegal.
Yes.
And then to set aside the impugn column 5, Mallards have already addressed to that, that this has become infectious because in view of the declaration by the Honorable Apex. Now, as far as this petition is concerned, nothing survives in this petition after appointment of these petitions. And this we are not saying today. If Mallards should recollect, we have been saying it right from the beginning that after that appointment, this petition has been rendered. Now, Mallards should kindly come to the order passed by the Honorable Apex. Mr. Patwalia has already read this paragraph, but I will just once again I reiterate that because there is a very fine aspect involved in this. Can we see page 7? Every word has a meaning, and as the law says that there is nothing which can be termed as superfluous. Please have a look on page 7. As it appears that a large number of candidates with B.Ed degree have already been appointed on the basis of eligibility criteria specified by the Educational Authority, we do not think it to be equitable to affect their removal. We accordingly hold that the judgment delivered by this bench on 11 August 2023 shall have prospective operation. But prospective operation of this judgment, now here onwards, please see. But prospective operation of this judgment shall be only for those candidates who are appointed without any qualification or conditions imposed by any court of law, to the effect that their appointment would be subject to final outcome of the case, which might have been instituted by them. It's institution by them. And this word has got a meaning. Why it is said, like, please see, number of cases when the petitioner files a petition before your lordship, he makes a prayer for interim relief. Sometimes Mallards permit them, grant them that interim relief, but Mallards also specify that their relief, which has been granted as an interim measure, will remain subject to outcome of the writ petition. And it's not only that Mallards go to the extent of saying that no equitable flow in their favor out of that interim order. This situation is like this, that if a B.Ed candidate had gone to the court saying that we have been selected, yet the government is not giving us appointment, and then the court would have said that grant them appointment, court would have directed the state government to grant them appointment, but that appointment will remain subject to outcome of the writ. The situation is like this here, that the Supreme Court says that the proceeding instituted by them. Now, here is a situation where I pointed out to your lordship. Advertisement is issued on 6/1/2020. Writ petition is filed on 13/6/2020 after participating in the process. The interim order is passed at our back. We are not participating in the proceeding at that stage. So there is a difference now that if these proceedings were instituted by these B.Ed candidates, and if this interim order was passed, and their instance, it would have a different connotation. Then, the interim order passed in a petition which is filed at their back, and Supreme Court has not viewed. It could have been left like this, that if any what was the necessity of adding this word, that they might have been instituted by them. it could have been said only that the final outcome of the cases which have been instituted. But the Supreme Court has used that word, the word then. Therefore, my submission is this word, that makes a difference. That the appointments were, firstly, we say that this Kesri Nandan's case, one of this interim order was passed in the Kesri Nandan's case, which has already been rendered infraction. Now, second aspect is this, that even if it is assumed that this interim order survives, even then now this interim order is not passed by on a petition filed by the candidate of B.Ed category. This is the petition filed by the DLED candidates. Now, the learned Advocate General has already pointed out to your Lordship the order passed by the Calcutta High Court. And one of the Calcutta High Court has very categorically said that because there is nothing to adjudicate him. As far as this aspect is concerned, Supreme Court has said that this is the order. And now this order has to be implemented and everybody has to implement the order as per the letter and spirit as per the direction passed by the Supreme. Therefore, my submission is this that.
So the petitioners in these, in the first case and the second case, petitioners are diploma holders. And in the third and fourth and all.
Petitioners in the first case, also they are also the DLED.
They are diploma holders.
Yes, they are
diploma holders. Yes. And what about third and the up till?
Well, they all are diploma.
All are diploma.
All are diploma. That is what I say. That
all are diploma holders. All of
them.
There
would be no cause for the B.Ed candidates to come to court, my lords. It's obviously only the diploma candidates will come to court. This is such a twisted interpretation. If you see that, if the B.Ed candidate had come to court, he will not get a protection. That is the suggestion here. Because otherwise everybody else gets protected.
In 2 courts,
but
the B.Ed candidates went.
Court will not get a protection.
B.Ed candidates went to court in Rajasthan and B.Ed candidates went to the Supreme Court in Chhattisgarh.
This was a Madhya Pradesh application in the Supreme Court.
For the simple reason that the Rajasthan government did not accept government's 2018 notification. Because Rajasthan government did not include the B.Ed in the exam.
Please let Mr. Gildal complete.
Yes.
Yes.
My submission is this. The order passed by the Supreme Court has to be read in that respect. And with that alone.
So according to you, all these protection is only to B.Ed appointees.
This protection is
to B.Ed appointees.
To B.Ed appointees now, because there are the conditions Supreme Court has imposed. Firstly, that the judgment applies prospectively. So the appointments made, they are already protected. The only matter was that there should not be any order passed by the court subject to outcome in the proceeding filed by them. There is no proceeding filed by them. Otherwise, there was candidacy. This could have been left by without adding this term then.
All these conditions imposed relate to people who are B.Ed and were appointed and then approached the court.
Yes.
Did not.
In some states, not B.Ed.
That would never happen.
In some states, the rules did not permit B.Ed
This
to
is
come.
only about Madhya
For example, Rajasthan. Rajasthan rules made B.Ed ineligible.
Rules permitted B.Ed.
Here, MP rules permitted.
Yes.
Rajasthan rules did not permit. So Rajasthan, the B.Ed candidates went to court and got an interim order saying that you can participate in the selection process.
This entire clause is an exception to the protection.
In Chhattisgarh,
It's
kindly
don't
interject.
It must be
In
read as
don't interject. In Chhattisgarh,
you also
the court held that B.Eds are not eligible.
Exception to the
so
protection,
the B.Ed candidates
and
went to the
must be read as
Supreme
that.
Court and got an
Otherwise,
interim
the
order.
B.Ed candidates would have the protection, provided, however, that there was no order. Otherwise, they have the protection regardless of whether they have a petition or an interim order. Or
in 2 states,
there's
the
no
B.Ed
exception
candidates had gone to court.
The entire law is struck down and they get all
and
the
Chhattisgarh.
There was no disqualification as far as in the Lords,
we can't lose sight of
to
the
the court
fact.
about what he argued in Supreme Court.
My lords, we can't lose sight of the fact that Rajasthan High Court had already struck down that qualification and the advertisements came after that.
Let Mr. Gildal complete, please.
Court, we need not to go into that now. The Supreme Court was valid, now what has been said now, it's not immaterial now. The Supreme Court said that our judgment applies prospectively. Being there, by the decision of the Supreme Court, the B.Ed candidates are not to be treated as eligible, and their appointments have been protected. And the rules of Madhya Pradesh, now they permitted the B.Ed candidate, as the rule existed at the time of issue of advertisement, the rules permitted the B.Ed candidates.
No, and rules permitted the B.Ed candidates also to be eligible.
Yes, yes.
Also.
Yes, also.
Besides diploma.
Yes, diploma and B.Ed. And also, please see, it has been always been said that if these seats are given to B.Ed candidates, what will happen to B.Ed candidates, because they can only go for the primary teacher's appointment and they have no other avenue left over. This is absolutely incorrect. Please go through the rule. Rules, they permit the B.Ed candidates not only to participate for primary teacher, but they are also eligible for middle teacher. This has all, this would not be pointed
The
out.
relevant rules are on record? Not. P1. In which case?
The advertisement is clear. For this 2018 statutory rules, supply.
No, in which case?
These rules are in Kesri Nandan's case.
First case.
First case.
Yes.
These rules permit that
which is the relevant column in that schedule? This is
column 5 of schedule 3. That's what our prayer was for.
P1 is within 595. My lord, P1 in both the cases.
Please see room page 70.
Column 5 schedule.
71 or 38?
No, it's not 70.
38.
Or it is rules are in Hindi.
38. Page 38.
Page 30. Page 38. And in these rules, the what the nature of
कम से कम 50% अंकों के साथ हायर सेकेंडरी अथवा इसके संपर्क
Maharashtra में please see
अथवा 50%
अथवा is or.
अथवा 50%
अथवा is or.
अथवा yes. Schedule 3 Maharashtra is looking schedule 3. Yes. माध्यमिक शिक्षा.
नहीं, प्राथमिक शिक्षा का है ना ये.
प्राथमिक शिक्षा के लिए प्राथमिक शिक्षा yes. What I was trying to point out is that B.Ed candidate is not only eligible for प्राथमिक शिक्षा, that is the primary teacher, but they are also eligible for the middle teacher, madhyamik शिक्षा.
No, we are not concerned with middle madhyamik teacher.
It has been said, Manoj, it has been argued that if the B.Ed candidates are deprived of their opportunity of appointment as a primary teacher, they have no other avenue open to them, because they cannot apply for madhyamik शिक्षा and uच्च madhyamik शिक्षा. That is incorrect.
No, we are not here to adjudicate.
Yes, that is
everything has been done by the Supreme Court.
Yes,
we can't enter into that field of adjudication.
Now, प्राथमिक शिक्षा की qualification, Maharashtra, please have a look. प्राथमिक शिक्षा. Now, it is Maharashtra. कम से कम 50% के साथ हायर सेकेंडरी अथवा इसके समकक्ष प्रारंभिक शिक्षा में 2 वर्ष का डिप्लोमा के साथ अथवा 50% अंकों के साथ स्नातक अथवा शिक्षा स्नातक B.Ed. Now it is B.Ed. शिक्षा स्नातक मीन बैचलर इन एजुकेशन B.Ed. जिसने राष्ट्रीय अध्यापक शिक्षा परिषद मान्यता प्राप्त संस्था से स्नातक की उपाधि प्राप्त की है, उस पर कक्षा 1 से 5 तक पढ़ाने के लिए अध्यापक के रूप में नियुक्ति हेतु विचार किया जाएगा, क्योंकि अध्यापक के रूप में एक व्यक्ति को राष्ट्रीय शिक्षक के रूप में नियुक्ति होने के 2 वर्ष के भीतर राष्ट्रीय अध्यापक एवं शिक्षा परिषद द्वारा मान्यता प्राप्त प्राथमिक शिक्षा में 6 महीने का एक सेतु पाठ्यक्रम आवश्यक रूप से पूरा करना होगा, अथवा कम से कम 45% अंकों के साथ हायर सेकेंडरी अथवा इसके समकक्ष अथवा राष्ट्रीय अध्यापक शिक्षा परिषद मान्यता मानक एवं क्रियाविधि विनियमन 2000 के अंदर प्रारंभिक शिक्षा शास्त्र में 2 वर्ष का डिप्लोमा अथवा कम से कम 50% अंकों के साथ हायर सेकेंडरी अथवा इसके समकक्ष का प्रारंभिक शिक्षा शास्त्र में 4 वर्षीय स्नातक उपाधि B.Ed. अथवा कम से कम 50% अंकों के साथ हायर सेकेंडरी और इसके समकक्ष शिक्षा स्नातक विशेष शिक्षा में 2 वर्षीय डिप्लोमा अथवा स्नातक उपाधि प्रारंभिक शिक्षा में 2 वर्ष डिप्लोमा अथवा इसके समकक्ष आरक्षित वर्गों जैसे अनुसूचित जाति, जनजाति, अन्य पिछड़ा वर्गों तथा निःशक्त व्यक्तियों के अभ्यर्थियों को अर्थकारी अंकों में 5% अंक की छूट है। So
B.Ed was added
B.Ed is also there
as one of the alternative eligibility criteria. And this was struck down. This has been struck down.
Now it has been.
I'm sorry to interrupt, Malad. That has not been struck down. Your lordships will have to strike it down. It's the Madhya Pradesh rules. Nobody else has struck it down. In terms of Supreme Court's finding, your lordships will have to strike it down formally. That's prayer 7.5 of our writ petition. Nobody has struck it down so far. Your lordships will have to strike it down.
And what happened in Rajasthan?
In Rajasthan, it was the NCTE notification, Malad. The underlying one, that was struck down.
Rajasthan, the rules did not permit B.Ed to.
The rules did not permit, so there was no challenge to the rules.
Rajasthan
The challenge
rules
was
did
to
not
the
permit
NCTE
B.Ed.
notification. And the court in fact held over there that despite the Rajasthan rules not having been amended in accordance with NCTE, you had deprived B.Ed candidates from taking part. So there the Rajasthan High Court said you should have allowed B.Ed candidates to take part until the stage at which the NCTE notification was formally struck down. But
So
here
Rajasthan, what happened, my lord, the Rajasthan rules did not allow them. The NCT notification said they are eligible. The advertisement did not allow B.Ed. And therefore, the B.Ed people went to the High Court, saying we should be allowed to compete.
In the light of washing of this NCT notification,
yes,
rule also has to be struck down.
Correct.
Yes,
correct,
it has
correct.
to.
Now,
Yes.
from now the rule, now once the notification goes, the rule also cannot survive because the court says B.Ed are not eligible.
Since the mother body of teaching education.
Correct. So therefore, the question arises, what happens to people who were eligible under the state rules and who have been appointed? That's the issue. And there, our interpretation
That's
is
covered
the
by the
court said,
Supreme Court's order.
if the B.Ed people had not gone and secured orders, their appointments would be saved.
That doesn't apply to Rajasthan.
I don't think there is a rocket.
That doesn't
My
apply to
lord,
Madhya Pradesh.
frankly, the Supreme Court having struck it down and having held that B.Ed is not an eligible qualification for the purpose of appointment to primary, the question of anything further does not arise. Because
this B.Ed.
yes, my lord, so the rule
Yes,
as it
it's only
prescribes
DLED.
for yes, it's only
No,
Only
many states,
diploma.
not in many states,
Only diploma.
most states, almost all states, except Rajasthan and Punjab. In all states, B.Ed are eligible. Only 2 states they were not eligible.
lords, today the position is this that they are not eligible. Let us not forget that part. It has been found that their qualification is not eligible. They have to go. The only question is whether their appointments, they suffered a kind of a, my lords, an objection to their appointments, or there was an order that made their appointment subject to the outcome.
On which point?
Not on the point of this petition.
Because they had participated.
Yes, there are 3 aspects of the case. Firstly, no PIA, my lord, in the matter of service. Number 2, those who have not been arrayed as parties, against them you cannot get any relief. And third, very important is that my lord has been putting right from the beginning question, which is the date of the advertisement, which is the date of filing of the petition. All of them have participated in the selection process, and at the end, my lord, when they said that exams we could fare well, then they filed this petition. So, my lord, letter 3, 2010, volume 10, SCC page 707. That is J. Srivastava versus State of Madhya Pradesh. Come down, Lord. To para 15 of the order.
Yes.
My lord has come to para 15.
Yes.
Very with my lord's information.
Yes.
In para 14 of the however, the main argument by the appellants against entertaining WPC and so is on the ground that a PIR in service matter is not maintainable. This court is of the opinion that there is considerable merit in that contention. It is common ground
The dispute in this case is an over-selection and appointment, which is a service matter. In Duryodhan Sahu, Doctor versus Jitendra Kumar Mishra, that is 2010-10 SCC 707, a three-judge bench of this decision held that a PIL is not maintainable in service matters. This court, speaking through Srinivasan J, explained the purpose of administrative tribunals created under Article 323A in the background of extraordinary jurisdiction of the High Court under Article 227, 226. This court held if public interest litigants at the instance of strangers are allowed to be entertained by the administrative tribunal, the very object of speedy disposal of service matters would get defeated. Same reasoning applies here as as public interest litigation has been filed when the entire dispute relates to selection and appointment, just like my case. Para 16. In B. Srinivas Reddy, that is 2006, volume 11, SCC 731. And this court held that in service matter, only the non-appointees can assail the legality of the appointment procedure. That is the end of the matter, Lord, in most of the cases. Para 17. This view was very strongly expressed by this court in Dattaraj Nathuji Paware versus State of Maharashtra, that is 2005, volume 1, SCC 590, by pointing that despite the decision in Duryodhan Sahu, PILs in service matters continue unabated. This court opined that the High Court should throw out such petitions in view of the decision in Duryodhan Sahu. The same principles have been reiterated in Ashok Kumar Pandey in a recent decision of this court delivered on Peace Plus. Thus, in Banchlal, it has been held that except in a case of co-warrant of PAL in a service matter is not maintainable. Now, para 20. The next point urged by the appellants that they have never been included in the two petitions, even as the orders passed by the High Court had a direct effect on their livelihood, also goes to the root of the matter as it violates the principle of order. Here also, Lord, I spoke to my Lord only in two petitions. Look, please hear me. In one case, I'm respondent. In other case, I'm intervener. Now, para 21. This court in Prabodh Verma versus State of UP held the High Court ought not to decide the writ petition under Article 226 of the Constitution without the person who would be vitally affected by its judgment before it as the respondents. They have never bothered to make any of us as parties block. So many of them selected. Similarly, this court in Ramar, all these judgments are recorded. And para 23 में, there is another important judgment. Para 23 B. Ramajini versus State of Andhra Pradesh, where selection of certain teachers was challenged without implementing them. This court held selection process has commenced long back, as early as in 1998, and it had been completed. The persons selected were appointed pursuant to the selections made and had been performing their duties. However, the selected candidates had not been included as parties to the proceedings, either in the individual capacity or in the representative capacity. In that view of the matter, the High Court ought not to have examined any of the questions raised before it in the proceedings initiated before it. To that extent, the Supreme Court has gone. The writ petitions filed by the respondents concerned ought to have been dismissed, which are more or less in the nature of a public interest litigation. So, Lord, this is the judgment of Girjesh Srivastava. I have requested my Lord's leader also to show me another judgment. That is called Lord Saroj Kumari, 2017, volume 9, SCC, page 478. Because Lord,
on the same point.
No, it is on the point that they were very happy appearing in the exam, my Lord. Aram se exam hai. Lord, the rules were published, Lord, way back in 612. My Lord, everyone has given the chronology to my Lord. I have also given the chronology in my return. उसमें मैंने तारीखें बताई हैं. ये हाँ जी हाँ, ये रूल है 28/6/2018 को एक रूल हुआ, मध्य प्रदेश का रूल 1/7/2018 को हुआ. Everyone is very happy. 6/1/2020 primary school teacher eligibility test advertised and everyone participated peacefully on 5/3/22. After having participated, my learned friend Mr. Vidya said that this WPKC London was filed on 13/6. No, Lord, it was filed on 16/6. On 16/6/2020. कोई बात नहीं, एक मिनट का फर्क. So 5/3/2022 को they participated in the eligibility test, knowing fully well that along with me these B.Ed candidates are also appearing. I am representing all those B.Ed candidates, Lord, who have been selected, appointed, they are working on the basis of this advertisement, and these candidates were very happy. So, Lord, what Saroj Kumari says, Saroj Kumari is absolutely clear on this topic, not para 4. The main ground urged on behalf of the appellant is that respondent number 1, having taken part in the selection process, could not be permitted to challenge after she was unsuccessful. Now, Lord, para 5, we only one sentence that makes the position clear. Para 5 में in G. Sarma versus University of Lucknow, the petitioner, after appearing in the interview for the post of professor and having been not selected, pleaded that experts were biased. It was actually not made. Now, Lord, para 8 is important. Ramesh Chandra Shah has been quoted with approval in Saroj Kumari's case. Ramesh Chandra Shah. That is also 2013, volume 11, SCC, page 309. Saroj Kumari का case.
Yes, yes.
इसको कोट किया है सर. I would like to read with my lord's kind permission. Para 8, Lord.
Yes, yes.
Para 8 में para 24 is quoted. In view of the propositions laid down in the above noted judgment, it must be held that by having taken part in the process of selection with full knowledge that the recruitment was being made under the general rule, the respondents had waived their right to question the advertisement or methodology adopted by the board for making selection, and the single judge and the division bench of the High Court committed grave error by entertaining the grievance made by the respondents.
Not Mr. Lukra, if I rightly remember, maybe I'm wrong, that on this point there was some difference of opinion in the Supreme Court itself, and it was referred to a larger bench. Some recent view has come or not?
No, not that. It might have been distinguished. I don't think it is over because
when can a person who participated can still challenge or not challenge? To what extent he can challenge?
You have to vent your grievance before the commencement of the election. You have to, because when I was appearing for the radio deputy, I used to use the because people used to come after the selection process. Now, Lord, the most important thing is that, Lord, all these questions regarding whether B.Ed, I am representing those B.Ed candidates who have been selected, appointed. They are working. Now, Lord, as far as K.C. Nandan and Rohit Kumar, this K.C. Nandan petition is concerned, it goes because of not this judgment which I said, Lord, Srivastava. Because, and as far as the other petition is concerned, even in that law, they have not, my Lord, bothered to erase any of the selected candidates. Everyone knew that the selection and the appointment had been done. Lord, way back, appointments of the interveners was issued on 30/3/2023. उसके बाद सब petition पेश की. Then why not make any of them the parties? No, I will not make them parties, but they are. Now, Lord, my Lord,
No opponents are made when the petition is filed.
he made one point. I want to reiterate that. That is it. That, Lord, that there may be many cases in which B.Ed candidates might have lost in high courts. I want to make that. Many candidates, Lord, B.Ed candidates might have lost in the high court. Then they went to Supreme Court. Supreme Court would say that no, your appointment is subject to the final decision of this SLP. So in a petition filed by them, if their appointments are subject to the final decision, that is what the Supreme Court judgment says, Lord. Everywhere they say their appointment would be subject to final outcome of the case, which might have been instituted by them.
Yeah.
We have not instituted any case. State of Madhya Pradesh was very happy to entertain B.Ed candidates. We participated in the selection process. So, strict interpretation, exact interpretation of the.
So that was still India has submitted.
Yes, sir. I adopt his argument and the argument from my learned friend, Mr.
May I respond to these arguments, Manoj, for a minute?
You want to say something?
Yes, I just want to respond to two things. One,
You are appearing for
the fact that we didn't.
All these arguments not done by all these arguments done by all others, Lord, except Vipin Kumar Dwivedi, are not worth considering. That is my most.
But मेरा क्वेश्चन सिर्फ इतना है, ऑनरेबल सुप्रीम कोर्ट ने साफ कहा है कि दो सेट बनेगा। पहला सेट उनका जो किसी भी प्रोटेक्शन को लेकर के वो अपॉइंट नहीं हुए, वो है मध्य प्रदेश लॉ। बहुत सारे ऐसे स्टेट जिन्होंने बीएड को अपने नोटिफिकेशन में लिया ही नहीं, तो उन्होंने साफ तौर पर ये कहा है कि जो प्रोटेक्शन के साथ अपॉइंटीज हुए उनको निकाल दिया जाए। मध्य प्रदेश में 11/10/2023 के पहले एक भी बीएड अपॉइंटीज जो है हाई कोर्ट नहीं आया, किसी भी कोर्ट नहीं गया, ना ही किसी कोर्ट ने उसको अपने ग्रांट करके के द्वारा उसको अपॉइंट किया। लॉर्डशिप यह सेफ, तो हमारा ये कंसर्न यहाँ पर लॉर्डशिप की हमें ना तो केसी नंदा से ना किसी चीज इनकी जो है, हमें तो माननीय सुप्रीम कोर्ट ने साफ तौर पर सेट 1 में रखा है और मध्य प्रदेश सेट 1 करना है।
Manoj, can I just respond to what my friends had said?
Yes.
Number one, as far as not making them parties, when we filed our petitions, no appointments had taken place. So there was no question of making anybody parties when we made our when we filed our petitions. Second, all those petitions had interim orders which made it clear that it was subject to the outcome. So we presume that the state, if they are going to make appointments, are going to be informing the people they're appointing that it is subject to the outcome of court proceedings, to the which the state is very much a party at that point of time. Point number 3, repeatedly they have drawn attention to these words at the top of page 8 of the Supreme Court order. Let me just read that again so your lordships have the entire context of it, because they've for some reason decided to amputate that sentence. Let me just read fully that entire paragraph from bottom of page 7. As it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of eligibility criteria specified by the educational authorities. So this would necessarily have to include B.Ed as an eligibility criteria for them to be appointed. We do not think it to be equitable to effect their removal. Therefore, this is not considering a Rajasthan scenario at all. We accordingly hold that the judgment delivered by this bench on 11th August shall have prospective operation. But prospective operation, from here the exception starts, where they will not have the protection. But prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or condition imposed by any court of law, to the effect that their appointment would be subject to final outcome of the case, which might have been instituted. These words by them is what they're emphasizing, saying that it could only be if it's filed by the B.Ed candidates. By them, I would interpret to mean by whoever the petitioners are in that particular case, because the rest of the sentence makes sense, which might have been instituted by them, and such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement where B.Ed was stipulated to be valid qualification. B.Ed was stipulated to be a valid qualification in Madhya Pradesh, not in Rajasthan. No B.Ed candidate would go to the court when B.Ed qualification is given in his advertisement. He would only go when it's not given. Therefore, it is very clear that this petition, this order provides that B.Ed candidates who had qualifications provided in their advertisement, who had participated and then were made subject to a order of the court, will not have the protection, provided they were appointed prior to 11th August 23. If you're appointed after 11th August 23, there is no protection. That I think even Mr. Patwala will concede That is the nature of the prospective order.
When were these petitioners appointed?
These now, as far as the
There are two orders,
interveners are
Lord,
concerned,
30th March 23 and 10th August 23.
now 10th August 23 is not an appointment. Your Lordship may check that. There's not one single appointment which took place on 10th August. It's a notification listing those who would be appointed. So the appointments themselves took place after 11th August 23.
March 2023.
So they are all before the judgment.
Correct. They have all been appointed.
Some of them are
the
before,
judgment.
some are after.
They have all been appointed before
Your
the
Lordship may
judgment.
ask for the list from the state with the dates of appointment. My Lords, our unequivocal submission is that every single appointment took place after Your Lordship's interim order. The minute it took place after Your Lordship's interim order, they lose the protection.
August 2022. The result was prepared not very before time and it was declared on 8th of August 2022.
The interim order is 7 July 22, which takes note of the Rajasthan High Court judgment.
Nandan is out. We are not considering.
With Bipin Kumar, there was an interim order.
Please, my lords, on the 16th of January 23. 16th January 23, much before the appointment on 30th.
July 22, 7th July 22 in my case, in Kesri Nandan, Your Lordships took note of the Rajasthan High Court judgment and specifically said in view of the above.
You give us that within 2-3 days within this week. Please give us that.
We'll give you a note, my Lords, with all that.
Date of appointment. That is all. The
date of appointment are
My
only
lords,
2 dates.
I had pointed
The
page number
appointment orders
16.
are 30th
Page number
March
16 of the
2023
compilation.
and
Page
10th
16.
August 2023.
Mr. Patwalia, to make it easy for the court,
And-
it is the
and-
state
and-
government
and just 1 minute,
affidavit.
madam. And the appointment orders are clear. They are not subject to anything. They are categoric orders of appointment. And
So
they are
court's
not on
orders are
petition.
categorical. Court's orders make it subject to.
Yes.
Government can't decide to do what it wants on its own.
My lords, just to assist my lords, please see page number 16. This is a part of affidavit of the state of MP filed before Supreme Court. It starts at page 13 of the compilation and page number 16. There's also one thing out there. While according to them, 11,583 out of which 2,784 being made on that notification on 10th of August 2023, which they state, they clearly say 284 have been made after 11/8. And they write that they had only issued a notification and that the appointments had to be sent later on, which is mentioned there.
All right. So these first two cases, they are diploma holders. What about the remaining? All of them are diploma holders.
My lords, there was no need for the B.Ed to approach the court in Madhya Pradesh because under the existing thing, B.Ed were eligible. So the challenge to that was made by the diploma holders. And my lords, may I just in 2 lines respond to what has been argued? I would respectfully submit that I heard that argument being made on the other side, that whether in person or in representative capacity. Now, in representative capacity, impleadment was filed before Supreme Court on 11th October 2022, where Supreme Court reiterated the same stay of being subject to the orders issued in the petitions in the case. Now, they were aware even at that time, all the B.Ed, and subsequently the B.Ed have filed their impleadments. So, my lords, that argument and showing all the judgments of not being made a party, etc., is actually holds no water for the reason that they have been before my lords, and the courts have held that in any manner a representative capacity is sufficient in these matters.
All right. We are resolving the case and asking the state to file a tabular illustration.
Please, my lords.
Believing that after extensive arguments, the case stands reserved for passing final orders. Next, for the council, the state is directed to file a tabular illustration mentioning the date of appointment. Date of appointment of whose appointment?
B.Ed.
Appointment of the B.Ed candidates.
B.Ed.
So date of appointment letter being issued, that would be important. Date of appointment letter being issued, not the notification.
We'll reserve it and wait for yours. That we have.
Grateful, Manoj. Grateful.
Very grateful, my lord, for the hearing. Very
Point
grateful.
five? Locus. Wait, on what point? What is the point?
They did so far as the player A and B in the repetition are concerned. We find force in the submission of the learned attorney general. But insofar as the player C of the repetition is concerned, it raised an important public issue and involves the interpretation of Article 156 of the Constitution of India. And again, that's why we do not think that we can rely locus to the petitioner for raising that issue. The honorable apex court.
What is Article 156?
156.
What has that got to do with service matter?
Article 21. A. The right to education.
No, you are talking about Article 156. उससे इसका
Article 21A granted the fundamental right to the children, right to education. The eligible candidate who secured the B.Ed degree, they have not qualified to impart the children belong to age 6 to.
No, that 21A, Mr. Counsel, is children centric.
Yes.
Not
Not to do with the teachers at all.
Where is that issue open now?
वो आप दे दीजिए फोटोकॉपी दे दीजिए फोटोकॉपी यस हो गया yes
Grateful, my lord.
Obliged, my lords. We are very grateful for very patient.
Very grateful.
Great.
Roll number 39. Is Anwar
just always
Lots of matters primarily argued.
39
And Wednesday rule.
39
What's 39?
CRC
Yes, Lordship.
due to paucity of time not possible to hear this space finally just on any Wednesday Thursday in the month of July.
roll number 47. Come back.
आपको पर बाद में लेंगे.
Roll number 47. Come back.
Change for directions. Plans हो गया है? कर दिया और इसमें learned counsel for the petitioner informs that the order, final order dated so and so by which this petition has been disposed of, stands complied with. By passing of order under section 14, by additional